Hey, you got a little bit too much ice in this one.
Do what?
I said you got too much ice in this one. All right.
30 minutes, that's why I do it that way. I do it, we got 30 minutes left. And, sorry, I hit the damn button 3 times, why is it not shutting? This is set up, we're good on here. Have you sweat?
No, I'm doing it now.
Okay, cool beans. We'll go back here then. How long have you been eating? Oh, let me take this. Work picture, that's it.
Can I have you go get me the device?
No. I'm gonna check my clicker, see if my clicker's working.
You have to look at the light when you click it. Because your thumb is so big.
This has been in my office, and I just wanna make sure it works.
Oh, so you got your own clicker, huh? So you think you're hot shit now? Yeah, you are hot shit.
Yeah, I was given a clicker. You see? So I just started hearing it, I said, well, hey,
Be advised, the sweeping of the courtroom has been completed. It's clear.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention. You shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket this morning is Ellerbee versus the state of Florida.
May it please the court. My name is Jeffrey Anderson and I represent the appellant, Mr. Terry Ellerbee. The first issue I'd like to address is the first issue in the briefs. And this is where defense counsel argued to the jury that his client was not guilty of felony murder because...
Just speak up a little bit.
Excuse me, sorry. He argued that his client, Mr. Ellerbee, was not guilty of felony murder because the shooting was accidental and it was done to distract Mr. Thomas Del Arco, the victim in this case, so that Mr. Ellerbee could escape from his residence.
Wasn't there we have an excusable homicide instruction. Isn't that what he was shooting for?
Well, that was one of the purposes, but he still was, none of excusable homicide has accident in it, part of it, but it also has other clauses. It has to be, for example, it has to be an accident during a lawful activity, so he'd still have to show that Mr. Ellerbee wasn't doing some unlawful activity for that to work out. And that's the problem with the felony murder. He's being accused of doing the shooting in the course of a felony. So he really has to deal with that.
Well, but in the overarching problem here, that defense counsel really did not have much to work with. Given the things that had been admitted to by the defendant and the other evidence, this was an extraordinarily difficult case to defend, and he's grasping at straws because only straws are there. Would that be an inaccurate observation?
I don't think that's correct because, first of all, he does the worst thing possible. He grasps at a straw by informing the jury on something that's not the law, which only a few minutes later they'd be instructed that during the course of the burglary includes flight from the burglary.
Do we know why he did it?
Well, he's trying zealously to get his client acquitted.
I mean, isn't my problem with this point, and you're an experienced defense lawyer, so you know it too, is that unless there is clearly ineffective assistance of counsel on the face of it, we really would prefer to deal with this if it has to be dealt with in post-conviction, where then the lawyer can explain why, whether it was a strategy, what he meant, and then we can evaluate it. It's very, very hard for me. This isn't a situation where he just, as Justice Kennedy was alluding to, that he just did nothing, and I don't know, it's a failed strategy. You're saying, well, if somebody misstates the law, it can't be. But I think you're better off, given this case, that it be something that we just deny without prejudice as opposed to rule on.
I think this is one of those rare cases where there's no other possible strategy, because what happens in a lot of cases, someone will use a strategy that may seem ridiculous, but they're doing it for penalty phase purposes. This strategy was abandoned for the penalty phase. There's no use of it at all. And in fact, some people say concede guilt because you'll be more credible for the penalty phase. And so this is not one of those.
I mean, it seems to me that what this defense attorney did was, with the case as it was described by Justice Kennedy,
where there truly was no real defense that could be mounted in this case, was really going for a jury nullification, wasn't he? He was really asking the jury, look, whatever he did when he went into this house, it was really over when this murder took place.
No, he told the jury, follow the instructions, I'll explain the instructions, I'm not asking for sympathy or anything like that. He distanced himself from any nullification. And he told them, here's what you're going to be instructed. Except he was wrong. He forgot that during the course of the burglary includes the flight from it. He just didn't know it.
If we accept that that was not just a flawed defense, but it was just because it's as a matter of law, something that couldn't even be brought. Where's the defense here?
He had other options, viable options.
Like what?
He had, first of all, he's got to negate the burglary for felony murder. I mean, that's clear. And he could have done it by a necessity defense. He had facts.
Wait a minute now. You talk about grasping at straws. Now, if saying that because he needed some money that he was under necessity that justified him going in there and burglarizing, I mean...
Going in there, his statement includes that he was desperate, that he was basically starving, that he had a small infant to take care of, and he went in there for food and some loose money.
He also said that I deserve to live better than this. And right before leaving for this particular home, that's what he told his lady friend. I deserve to live better than this. In other words, he wants a house, a place to live in, not live out in the woods. Or he wants food to eat for the things like that.
Once he had a chance to get the food, didn't he wait another hour for the man to come back home? Was it other necessity to need a place to live?
Well,
So he decided to take his house and kill him?
No, I don't think that's what would happen here. I think I don't think the evidence really supports that this was a lay-in-wait murder, which
I guess you
I'll
can
address
say
in
that
the CCP.
I would say this, that it doesn't seem to me that under this record that the prejudice undermining confidence in the outcome without more can be shown. I just think for your sake, for your client's sake, it's better to leave this to post-conviction and let the defense lawyer explain what strategies he's considered and whether this was a failed strategy and why he did it.
That may be where this court ends up going. Just let me mention one other thing about alternatives. He could have always argued, and especially in this case, that there's reasonable doubt as to whether initially this was a burglary or just a trespass.
What was the reasonable doubt? He went into a home that was not his, and so what's the doubt about whether this was a burglary?
The state utilizes, it's at volume 19, page 1785, and it's his statement to the police why he went up to the house. He went up to the house because he needed food and he was hoping for some loose money. He didn't say he actually went in the house at that time. It just kind of explains why he approached Mr. Del Arco to begin with. And then later on at 1803, the police, maybe it's just inartful questioning, they ask him, what did you find in the house? So he talks about things he found. The things that are missing there are what he took from the house. It could be reasonably argued there's some doubt because of the vagueness of his statements and the inartfulness of the questions and stuff that he was looking for things, and he went in there and looked around, and then Mr. Del Arco came back.
In any event, was it a general verdict form?
It was a general verdict form.
Unless you knock off CCP, there is more than enough evidence of premeditation in the way this murder occurred.
Well, we don't know if the jury found premeditation.
But in a general verdict, does it matter? I mean, in other words,
but when you're talking about whether he is providing some defense or adversarially testing felony murder.
I mean, you're not arguing, you haven't argued that the notes that were introduced in evidence were erroneously admitted into evidence?
They weren't admitted during the guilt phase.
They were admitted in the penalty phase only. So you're not arguing, so you're saying the jury wouldn't have heard that?
I don't think they were even, they weren't admitted during the guilt phase. I'm 100% sure of that. The jury didn't have that.
But the jury did have the fact that he was in the house, the man was not there, but he waited for him to come back.
No, I think that's...
He waited in the house, and then the man came home. Is that the scenario that went on?
He was in the house for 45 minutes, and the man came home.
Well, he watched him. It goes beyond that. He was in the woods, and he watched the victim, in this case, get in the car and drive into town. He had spoken to the victim earlier that day, and the victim gave him a cigarette. And the victim mentioned to him how he was going to go into town, into Okeechobee, which is a long drive. So he watched him leave, and after he left, he broke into the house, shot the dog, and stayed in the house for quite some time.
45 minutes.
Okay, and then watched them arrive, watched them park the car or the truck, and watched them walk into the house. Plenty of time to leave, even after he saw the elderly gentleman come back. So
yeah, let me just, because I'll cover a lot of these facts in my second point, because we're getting very factual here, and it involves the sufficiency of the CCP aggravator. If it's okay, if there's no further questions.
We're happy for you to move on to this point.
And our claim is the evidence is insufficient for CCP, and basically that the trial court's order on this is very speculative. In fact, the order even recognizes that there are rational inferences which I submit are inconsistent and non-CCP. For instance, the trial court's order lays out the sequence of events that the victim came back, then he went and started to make a phone call or made phone calls, and that it's a rational inference that the defendant thought he was calling the police. And, you know, the way it's laid out, it's almost like a reaction to the phone call.
Well, let's see that. Let's again. Now we're getting in the facts.
Right.
He comes into the house. He does something in the house, and then after he's finishing doing whatever he was going to do, he stays. He knows the victim, as Justice Labarga said, has driven away, but will be back. And so what is a logical inference as to why he continued to stay in the house with a loaded gun, waiting for the victim to come back, and having shot his dog?
Well, the logical inference is that he waited for Del Arco to leave and then went in the house. And if there was a burglary, it's based, and the motive for it is first to look for food and, you know, to cook food, to eat the food. And then he went through
Did he attempt to cook anything?
There was something mentioned in his statement somewhere that he had to cook something, tuna, I believe.
But there's more to the statement than just what he said to the police. It's also what he said to Amber Reed, his lady friend. And he told, Amber Reed testified that after being kicked out of the trailer where they were living out in the prairie, that Reed was aggravated. She mentioned that he was aggravated and said that he deserved to live better than this, and then walked off armed with 3 guns, you know, a bunch of ammo, and 4 to 6 throwing knives. Then he returned a couple of hours later with the Explorer belonging to this elderly gentleman that had been killed, and he was happy. And then he told her, the defendant told Amber Reed, it took him a long time to return because, quote, he had to wait for the man to get home.
Amber Reed explained...
Why is he waiting for the man to get home if all he wanted to do was just rob or burglarize the place?
The part about waiting for the man to get home, that Amber Reed testified in that context, I have my reply brief word for word, was in the context of a lie that appellant was telling her. Even Amber Reed realized it was a lie. It was just an excuse for coming in late. The whole sequence, because it was about borrowing a truck also. So that part was a lie. The
But we're talking
made,
about, competent substantial evidence to support CCP. That's one factor. Whether
Well,
you believe her, believe or not, whatever, that's another factor.
her main testimony is he made no statements beforehand about, hey, we got an opportunity to get a place to live. I'm going to do something about that. He had no even tenor of that. I mean, he had, the best, he had frustration over his current condition. But after the fact, he did state to her, we have an opportunity, we have a place to live now. But that's after the fact.
Okay,
It doesn't
but
show
can we go
this
back to
pre-plan.
when I was just alone, that after he finishes doing whatever he's doing, he lays in wait for a period of time. Now, if his reason for laying in wait was to rob him when he got back, he wouldn't have had him sit down at the table and start doing things. He comes up to him and he shoots him in the back of the head with a gun. If there's ever going to be someone that's going to say, well, maybe something's not HAC or CCP, it might be me. This is, to me, close to a classic CCP case. And it's worse because of everything that he said, what he planned to do before he came to the house, and what Justice Labarga is telling you. So I'm not sure where we were going was the judge got it wrong in his interpretation of the facts, and the judge should have interpreted the facts in a way that would have shown this was a spontaneous act when he panicked because he thought the victim was going to call the police. And
I'm saying that's one instance where the judge says that's a rational inference, that it seems to be in reaction to this phone call. But let me go to your hypothesis that this was a lay in
Did he
wait.
raise the rifle fire and shot him at the top of the head? Is that how the shooting took place?
Well, we don't know. It could have. This is one part where the defendants claim that this was an accidental shooting could be true, because the bullet enters the top of the head while the Del Arco's sitting at the kitchen table, and he shot at the top of the head, which the medical examiner dealt with that and said, well, it could happen. We got to know the position of the head. But one of the things that it could have been, that the record doesn't rule out, it could have been a ricochet shot, because what's found inside the victim's head is a fragment, not the whole projectile, but a fragment. And there's no exit wound. And the state never explains where the bullet fragmented. It could have been off a ceiling beam. We don't know, because they did the autopsy 4 or 5 days after they did the forensic work. For some reason, they delayed in the autopsy, so they didn't go back and do extra forensic work.
But
I
guess the thing is you're speculating about something that is far less logical, given the totality of the circumstances, than a planned lay-in-wait murder, kills the dog, plans this, knows he's coming to this house, he picks his victim, he picks somebody that is living alone, and waits for him to come back, and then shoots him.
Well, if this was, I know the state's theory is that all along this was a decision to get the house. There's several illogical things with CCP in the scenario you drew up. First of all, you don't let the victim, you're in a rural area, no one's around. If this is already planned, don't let them drive away and possibly come back with someone. If this was a lay-in-wait, you would expect the killing to be in the beginning. Second of all, when he returns, you don't let him use the phone, because you don't want him to call police or other people. That's not consistent with a lay-in-wait. And the amount of time he was in the place.
Why isn't that consistent if he has if the victim has no idea that the defendant is even there? There's nothing inconsistent with him letting him use the phone.
Except for the defendant's statement was that there was some indication he knew someone had broken in the house. Someone's broken in. That's what the victim is muttering when he's making the phone call.
Because he saw the dog, his dog was killed.
Right.
I mean, he knew.
That's the assumption, yeah.
Well, was the dog in the front of the house?
The dog was, it was in the front. You'd notice when you went in. I don't think it had been moved at that time.
Is there evidence in this record that would indicate that not only was the individual going to take this house for himself and these other two folks, but that the plan or the idea is to select an individual, had no relatives because statement was made, individual is there, has no relatives, and bury him in the backyard, nobody will ever know. Is there evidence in the record about this?
There may be after the fact in his statements to Emory.
So are you saying that any evidence that relates to his state of mind and what's happening at the time cannot be based upon statements made after the shooting?
No, I'm not saying, but I'm not saying it's controlling either.
Well, I understand, but I mean, is there evidence of that?
I think he made some reference when he talked to Amber Reed afterward that they can go in the house. He may have mentioned something about moving the body.
And burying the body out in the back, and that nobody will ever know. Is there evidence about this? So there is evidence.
I think he told Reed that.
Yeah, so I mean, and you agree that can be used or can be considered as part of the evidence in this case, correct?
Part of the evidence. I don't think it's sufficient.
I understand.
Right.
But if that's evidence that's here, then how can what the judge's his analysis end up being speculation? There's evidence in the record.
Because he's speculating as to a lay-in-wait killing. He's speculating that no burglary takes more than 45 minutes.
Okay.
Where the defendant went through every room in the house, there's evidence of that, through all the doors, all the cabinets, and looked for things. It can't be done, and he also looked for food and prepared food.
But what about, again, going back to what I mentioned earlier, his statement to Amber Reed? It took me so long because it took a long time for the old person to return.
Amber Reed, because there was the borrowing of the truck, Amber Reed even said that was a lie. That was an excuse. It was a lie, and it's not worthy of using a lie to build up CCP.
But that's her perception. That doesn't have to be the judge
or
the jury's perception of it, does it?
I don't think he'd use something that the witness saying he's lying to me about this, and this was part of the lie.
But it's logical. I guess the thing that I'm having trouble with is that the scenario of what we've been talking about, that is that he picked a vulnerable victim, he targeted him, he came with guns, and I don't know the question as to why he let him go first. Maybe he wanted, that would be speculation. And then the logical thing is that he laid in wait for him. Now, does this 21-year-old, does everything, he's not a contract killer, does everything about the murder then have to be completely consistent? No, we have, unfortunately, a lot of terribly misguided and worse defendants on death row that just, but this one is closer to logic than a lot of others, that he was doing it so that he could have a house to live in, and he planned to kill this man who was...
It's equally consistent with him waiting for Del Arco to leave, to go in the house and burglarize the house, and then Del Arco returning when he's doing that.
Why did he need such heavy armaments if he was simply going to walk in the house?
Well, he carried around a lot of stuff constantly. I mean, that's just what he did. He didn't do any special procurement for this particular thing.
And so we have like an automatic rifle, and we have handguns, and we have knives, and doesn't our law say that when you take to the scene weapons, that's something that can be considered in connection with an analysis for CCP?
There's got to be a nexus between that. He didn't need all that stuff. If he's been targeting,
how can he carry anything away with all the guns he's carrying?
Well,
you talk about speculation.
It's not so much that, and I don't even know if he went in the house with all that stuff. I doubt he did. I doubt most of that stuff was in the woods.
I have yet to hear any kind of plausible explanation for why he didn't just get out of there when the victim returned home. And this whole idea that he's going to shoot to cause a distraction. So I mean, that's ludicrous.
He couldn't, I know it's been said, the judge said he could have just snuck out. I don't think they're positioning the defendants in the master bedroom. Delarco's sitting in the kitchen at a table with a view of that.
But the notion that he's going to shoot and that's going to be a distraction, that's just going to bring attention to himself. I mean, it's just ludicrous.
Well, he can't sneak out. He can't sneak by him because he's got to go right by
so he shoots him.
Or he shoots to do a distraction.
But how is that a distraction?
Even if he decides to shoot him.
What I don't understand is how that could plausibly be a distraction as opposed to something that's going to draw attention to him.
Well, his statement was it's a distraction because it scares him. But even if it's not a distraction, forget about that. Say he shot him on purpose. At that point, if that's a reaction to him coming back during a burglary, it's not CCP, it's a reaction. And that's...
Well, we have other evidence here. You're now down to about 4 minutes and 40 seconds. So you can proceed, but you're into your rebuttal.
The key is this really a lay in wait? And it's not. He's interrupted during a burglary. It's equally consistent with that, if not more. And that's why I think CCP is insufficient in this case. I've covered most of the details better in my briefs, especially my reply brief. And it shows that a lot of this is stacking of all these inferences. Thank you. I'll reserve the rest of my time.
Thank you.
Good morning. May it please the court. Lisa Marie Lerner with the Attorney General's Office for the state of Florida. If your honors would permit me, I'll go straight into the CCP. As this court knows, the court has to determine whether or not the judge in his sentencing order applied the correct law. This judge did. He discussed the law of CCP, cited numerous cases, and then he took the facts from the record. This court reviews the record itself to see if there is competent, substantial evidence to support the trial court's finding of CCP.
Now, your opposition seems to take the position that that order doesn't correctly even recite the facts that were presented. And there are errors, according to your opposition, in that order, and therefore that it's an improper order and ought to be overturned. Would you very directly respond to your opposition's position with regard to those? Because it does appear, it seems in the order, that there are different statements that are, if not conflicting directly, certainly very, very close to being in conflict.
First of all, I don't believe that this court is bound just by the trial court's order and factual findings. This court can go back under Willacy and its progeny to look at the evidence in the trial record itself to see if there's evidence in the record to support the finding of CCP. In regards to the trial court's mistake in the order, it did make a mistake in its initial paragraph, I believe, under CCP, where it said that Ellerbee waited for Mr. Delarco to come home, and once Delarco went in the house, Ellerbee went in. However, I think that was just a misstatement, because on the record on appeal on page 582, again under CCP, the trial court is later expounding when it was discussing that Ellerbee could have easily escaped. It said that Ellerbee went inside the house while Mr. Delarco was gone and then waited for him. So clearly the trial court did know that Ellerbee broke into the house while Mr. Delarco was gone and then waited for him inside. And the first statement that was incorrect, I believe, was just a misstatement. The trial court clearly knew that the burglary occurred. Ellerbee stayed in the house and waited for Mr. Delarco to return. And on a finding of CCP or any other aggravator, this court has to look at the totality of the evidence, not individual facts taken out of context. And in this situation, you have Ellerbee targeting an elderly man. Mr. DeLarco had severe gout and arthritis. The testimony was he walked with 2 canes, he could barely move, he shook all the time, he couldn't see well, and he was nearly deaf. Ellerbee knew this because he had watched the house, and earlier that day had actually gone and gotten Mr. DeLarco out of the house on a ruse about finding his lost dog, and talked to Mr. DeLarco face to face. He saw the victim's condition, how weak he was. Mr. DeLarco was using 2 canes, had difficulty getting in the truck. So Ellerbee specifically targeted this victim. Ellerbee then goes into the bushes. When he had walked up to the house, he already had his rifle, his revolver, and his knives. He left the rifle, at least, in the bushes when he went to talk to Mr. DeLarco. He did not take the rifle up to DeLarco saying he was hunting for his dog. He hid it in the bushes. DeLarco leaves. Ellerbee goes back to the bushes, gets his guns, including the rifle, to take in the house to burglarize. There's no reason he had to move that rifle from the bushes to inside the house unless he was planning to use the rifle. Also, Ellerbee specifically targeted the eldest dog, Ricky, who was protective of DeLarco. He told the police that he took the revolver for the dogs. He shot Ricky. By shooting Ricky, he took away Mr. DeLarco's protection and the protection for the house. Again, showing intent to harm DeLarco. He took the other dogs and put them in the back porch. He could have put Ricky back there too, but he didn't because he saw that Ricky was specifically protective of Mr. DeLarco. So shooting the dog is also part of the CCP. He went in the house and he stayed there. According to Ellerbee's statement himself, he was in there a good hour or more. That's what he told the police. He had time to go through the house, to eat, to watch TV.
How big a house is it?
I believe it's a 2-bedroom. I don't have the size.
Okay, so it's not like a house that would take a long time to burglarize.
No, this is a 2-bedroom house on the prairie with, a living room, dining room combination, and a kitchen.
This prairie area is, in that particular neck of the woods in Florida, is a pretty big area. In Okeechobee, people go hunting there a lot. I'm just wondered, how was it, and maybe I missed it in the record, how was it that the victim in this case was found so quickly? How was it that the sheriff's office responded out there in the middle of nowhere so quickly? Because I think part of the intention, if I read correctly, was that he could shoot this elderly person, bury him out there, and nobody would miss him for a long time.
That is correct. Couple things. Mr. DeLarco had decided that he was going to move into either with his family or into assisted living because he could no longer live by himself. There's testimony about that. He had arranged to have his house cleaned to sell it, and the house cleaner came that afternoon and saw Ellerbee at the house. Because Mr. DeLarco was planning to move, he was in contact with his family. The family kept calling him because they were expecting him to, make plans to move. He didn't answer his phone, so the family asked the sheriff to do a welfare check. And the sheriff went out there twice that week. And the sheriff saw the dogs either locked up, sometimes in the yard, sometimes locked up. And also Mr. DeLarco's friend went out there a couple times to check on him, and he saw the dogs in, the dogs out, the garage door open, the garage door closed. So clearly there was someone there, and it was that friend on Friday who went up to the house, smelled something, and went in and found Mr. DeLarco. So he was there about a week, but the reason he was found is because DeLarco was planning on moving and had been talking to his family, and his family couldn't reach him.
Mr. Anderson makes the argument that if he had wanted to kill Mr. DeLarco, he wouldn't have let him go into town and come back. What's the counter to that?
Well, Mr. Ellerbee wanted the house itself, and he had to kill Mr. DeLarco. When he first encountered DeLarco, and he was talking to him, his guns were in the bushes. And he left, and DeLarco immediately got in the truck and drove away.
So there wasn't, DeLarco didn't go back the victim didn't go back in the house?
The victim immediately got into his truck, according to Ellerbee. Ellerbee then went in the house. And interestingly enough, and I mentioned this in my brief, Ellerbee told the police that when DeLarco came back, he saw Ricky lying in the front yard dead and was upset. Went in the house, did not see his other dogs, and so Mr. DeLarco, after he went in the house, while Ellerbee's still inside, then went outside. Went all the way around the house to the back, to the pool enclosure, to get the dogs out. The dogs were acting strange. The dogs wouldn't go out. He had to start swatting them to get them out.
So you're saying that this was not a situation where he comes home and immediately sees the dog is dead?
No, he did see the dog is dead, but Mr. DeLarco went in the house, couldn't find the other dogs.
Okay.
And Ellerbee's in the house. So Mr.
Well, that's, I mean, again, and not trying to, just to try to understand this, when he goes back and when he comes into the house, if the intent of Ellerbee was to kill him, why did he let him go back out of the house?
Because he was still moving around at that time. So
who was still moving around?
Mr. DeLarco was standing up moving, albeit on two canes. So Mr. DeLarco goes out. Ellerbee at that point has a chance to leave either by the front door or the back door because DeLarco's in the back of the house. But Ellerbee decides to wait. He waits until Mr. DeLarco comes in the house and is stationary. Ellerbee waited until Mr. DeLarco sat down and put his canes away, making him particularly easy to shoot, which again goes to CCP. If he was frightened because this man was coming home, he could have hit him over the head, he could have escaped while DeLarco was out. But no, he waited until his target was stationary, so the shot presumably would be more effective and easier to do, rather than just shooting someone who was standing up.
You know the nature of the phone call that DeLarco was making at the was he calling the police? Anything like that?
What we know is from Ellerbee himself. It does not appear that...
no phone records?
No. It does not appear DeLarco called the police because Ellerbee said that he got a recording and hung up when he got the recording, as if it were like an answering machine or some other sort of automated voice. And that's the only evidence we have. And Mr. DeLarco did not make any other phone calls. He was sitting at the table, and he had put the phone down. And it was at that point, when his head was bent down over the table, that Ellerbee took the opportunity to shoot him. And Amber Reed did say that he targeted this man because he was an elderly man by himself, living by himself. And the statement about him waiting for the man to return, even though Ellerbee was lying about getting a truck repaired or something, his statement that he waited for the man to return was accurate, and that's what he did tell Amber Reed. On the first issue, just to respond, this attorney, it's not clear from the face of the record itself the reasons why this attorney chose this strategy. And I do believe it was jury nullification, sort of a Hail Mary pass. He was challenging the premeditation, and he was challenging the CCP. So he did use this. It appears that he might have used this with an eye to the penalty phase.
But is Mr. Anderson correct, then he didn't resurrect the accidental shooting defense in the penalty phase?
He didn't resurrect that, but he argued there was no premeditation. He did argue.
But it doesn't make a lot of sense that if the idea was you're going to throw out that it was an accident, that you wouldn't use that then in the penalty phase where, you know, to try to avoid CCP and avoid the death penalty.
The focus of the defense attorney's penalty phase argument was on the mental health non-statutory mitigators. And that is primarily what he argued. Whether or not he had a strategy for this is not something we have before us, and that is one of the reasons why it's more appropriate to handle this, if at all, in post-conviction. And again, as some of the justices said earlier, with this record, the attorney had to find something to get the jury to try and prevent him from being convicted of first-degree murder.
Well, Mr. Anderson argues that he could have defended this based on whether or not there was a true burglary. Burglary is entering and remaining in structure to do what? Commit a felony? What was the burglary?
Theft. And I understand Mr. Anderson is in a similar position as the trial attorney. He doesn't have a lot to work with here. But Ellerbee said he went to the house to steal money, to get money and food. That was his intention. He didn't go to the house just to peek in the windows and look at the food. He went in the house to steal items of value and to steal food. Ellerbee also testified, and Amber Reed testified, that he had been burglarizing other houses in the area, stealing guns and other items. And Ellerbee also told that to the police. So this is consistent both with his other actions on the prairie as well as his prior convictions, which, interestingly, were for burglary and stealing guns.
Did he steal a gun in this house?
Yes, he stole a shotgun, as well as the money, the ATM cards, the credit cards, you know, and any other items he may have found useful there. And in terms of the necessity defense, he doesn't even meet, Mr. Anderson doesn't even meet the requirements for a necessity defense. It has to be to avoid imminent harm, and there is no other means to do it but the means he chose. And Mr. Ellerbee himself created the necessity by bringing them all out to the prairie. He had other means besides breaking into homes. He could have driven back to town. Amber Reed and her baby were signing up for financial aid from the state, and she was living with Ms. Hutchinson, who was providing her with room and food and shelter. So he had other means to avoid the problems of being out on the prairie with no food, water, or electricity by just driving back into town. And so necessity doesn't work either, nor does trespass. If the court has no further questions on any of the issues, I'd ask the court to affirm both the guilt and penalty phases. Thank you.
I'd first like to, and this all goes to the second issue, CCP. One of the things that I forgot to mention was Del Arco, when he was seated down, it wasn't far from the front door where he kept his rifle. And thus, if there's a possibility if you sneak out of the house, there's possible repercussions from that. I just want to mention that. It's not like other cases where there's no, the victim can't do anything about it. One of the, there were a bunch of representations about...
Wait a minute, you're saying that if he had gotten out of the house, that the victim would have been close to a weapon?
Yes.
So when did he take the weapon?
Well, he takes it after the killing. There's no evidence that he had it at, the time of the shooting. But it's vague.
If you're going to speculate, he could have had it already.
His statement's vague as to what occurred, and that's what we're basing, CCP on. A lot of the description of these things uses the word targets a lot, and has descriptions that, frankly, as to Del Arco's condition on that day, There was no evidence about him using canes on that day, and a lot of it's speculation now, and especially the fact that, or the claim that appellant specifically targeted Mr. Ellerbee for his house. Our claim is that these are assumptions. If you look at the record for things like that in the statements and what Mr. Del Arco was like on that day, there's no evidence that appellant saw Del Arco using 2 canes to get in the truck and then did this or that. That's a description that's not part of the defendant's statement, but it's being used now to argue that he's targeted Mr. Del Arco because of that. The statement to Amber Reed about the truck and about waiting is about the defendant borrowed the man's truck because he told Del Arco that he needed the truck to get some parts for his truck, which was broken down. And he had to wait to return the man's truck. And that clearly is not true. He didn't have a truck that was broken down. Amber Reed knew that was a lie. That's why you know in the context, Amber Reed knew this was a lie. Unless there are any questions, I'd ask this court to reverse.
We thank you both for your argument. The second case on today's docket is Wright versus the state of Florida.
May it please the court. William McLean representing Raymond Bright. This morning I'd like to address the sentencing issues in this case, particularly issue 2 dealing with the doubling of aggravating circumstance and issue 4 dealing with proportionality.
Before you get into that, I'm just curious, was second-degree murder a requested lesser in this case?
I would have to check. I'm sure that there was probably an instruction on that.
I just wondered.
Yeah, again, I'd have to. The sentencing order in this case, the judge doubled the prior violent felony aggravating circumstance. The evidence presented was that Mr. Bright had had a conviction for robbery in 1990, and then the 2 contemporaneous homicides in this case. Rather than addressing those as cumulative evidence to find one aggravating circumstance, the judge separated these out and found and weighed them as 2 aggravating factors, which our position is that's an improper doubling.
Well, let's assume that's correct, that we have then the contemporaneous murder, certainly, that's here. And so what impact does that have on our ultimate outcome in this case? It just goes into the proportionality analysis, correct?
Actually, no. I think there is, just on this argument alone, issue 2, it should be remanded at the very least for the judge to reconsider.
Well, if we assume it's wrong, I mean, you're saying that if we assume that if there's improper doubling, and we make that conclusion, but then we go on to look at the valid prior violent felony under these circumstances, doesn't that take, you're saying as a matter of law we have to reverse if we agree with that argument?
I didn't say as a matter of law you have to reverse if there's an improper doubling.
You're asking us to do that.
I'm asking you to do that in this case.
Okay, in the alternative then it comes into our analysis with regard to proportionality.
Yes, Your Honor.
Okay.
But you concede it's subject to harmless error analysis.
It is, yes. This court has used harmless error analysis for improper doubling of aggravating circumstances. In this case, it's a little bit unique because the trial judge, in addition, both in the sentencing order and in his oral pronouncement of the sentence, said but for the heinous, atrocious, and cruel aggravating factor, I'd be sentencing you to life. So the question becomes whether that improperly found doubled aggravating circumstance, where along the continuum of the trial judge's balancing.
But that's not the HAC.
It's not the HAC,
right.
but he said the HAC, basically he said, based upon the aggravating mitigating circumstances, without the HAC, I would give you a life sentence. But he'd improperly doubled the prior violent felony aggravator in the process. So we don't know whether if you took one of those aggravating circumstances off the scale, whether he would still find the balance point where he did, and whether the HAC would then convince him that
But he
death
says
was
without
appropriate.
the HAC. It seems to me that he's saying that, if there was no HAC, he would be entitled to a life sentence. If we keep the HAC, whether we have one or two, it seems to me that he's saying,
Well, the question is, he obviously made a balancing point. Here's my aggravators, here's the mitigators. But he improperly doubled one of those aggravators before we get to the HAC. So the question is in the judge's analysis, is he going to reach the same balance point?
Here's my problem with that. If we're counting aggravators and the improper doubling was pecuniary gain and robbery, which is we know merges. But here, I know we've said that the fact that there's a contemporaneous felony and a prior violent felony goes just into the one aggravator. But you can't tell me that when you're looking at the strength of that aggravator, the fact that this is a defendant that previously is convicted of a prior violent felony, and there's a contemporaneous felony of that there's two victims, doesn't give that very, 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 very great weight. We often say HAC is one of the weightiest. For me, killing two people and having had a prior violent felony, to me, that's the weightiest, because that is showing somebody that has an escalating pattern of violence, and then is now, so going back to the issue of whether it's harmless, it just doesn't seem that the fact that it can't be doubled, but it still makes that aggravator more weighty because of it, unlike a pecuniary gain and robbery, which is just the same thing. This is two different things. So what's the answer to that?
Well, I think you have to take into account the nature of the violent felonies here. Mr. Bright had a long history of chronic alcohol and drug addiction. He would go through sometimes periods of years where he was very productive, he had responsible jobs, and then he would relapse. He was in his early 50s when this occurred. So it was during a relapse period that this robbery occurred in 1990, where he walked into a convenience store with a knife and robbed him. There was a police officer who witnessed the entire event. He was placed on probation for this offense and ordered for alcohol treatment. The two offenses in this case, he was in a period of relapse.
So I guess, again, we were just talking about harmless error. Mm-hmm. If the judge, he sees the prior violent felony and he sees the contemporaneous felony, whether he calls it two different ones or it's part of the same, it's not the number of aggravators, it's the quality and quantity. So, the quality of it, not the quantity. So if it's not a terrible prior violent felony that you're putting in with the contemporaneous, the weighing process, to me, doesn't change, unlike another. Tell me what's wrong with what I'm saying. In other words, you see, it's that we don't count them and say, well, because there's 5 here. We would still look at it, whether it's two that come into one aggravator, it's still two different things. A prior act of violence and a current felony of violence.
I understand we don't have a counting process. However, in this case, given the trial judge's explicit statements Again, he explicitly said this would be a life case, but for the heinous, atrocious, and cruel aggravating factor for him in his reasoning process. Now, he was taking into account 2 aggravating circumstances before the HAC rather than the 1. So taking the 1 off the balancing act, we're speculating as to what the judge may have reasoned.
It doesn't change, though, the way you evaluate it. You go and say there was a prior violent felony and a contemporaneous felony. Whether I call that 2 or 1, that's why we don't look and count. So I understand your argument. Okay. I just, that's why I have problems with that part of the argument. But what about on the proportionality? Or let me ask you, going back to something, how tall was this? How tall and how much did this defendant weigh versus these 2 the victims that were much younger than he was? Because I'm trying to figure out how he ended up killing through bludgeoning 2 younger victims. The defense is that he thought he perceived a threat because they had guns. Were they the ones that had the guns?
Yes, they were guns. What had occurred here is during this period of his relapse, he lost his job at that point, and he actually rented a room in his house to 2 young men who were drug dealers. One of them was the victim in this case. The other young man, Randall Brown, was a visitor. He had been trying to get them out of his house because even though he was being paid in drugs and money from them for rent, when they started dealing out of the house, cooking the crack cocaine in the house, bringing guns into the house, he became afraid of them, and he had made efforts to try to get them out of his house, including contacting the police, but the narcotics division just wanted him to become an informant, which he was afraid to do. So this was the backdrop for what happened here. He, according to a statement that he made to his friend, Mr. Lundy, which the trial judge acknowledged in the sentencing order, he awoke during the night. These 2 young men were still in the living room of the house, and Mr. King, I think it was, the one who was the dealer, confronted him about, hey, you've been stealing my drugs, and the struggle ensued. There was 2 firearms.
The guns, okay, because there is, when outside of the house, the crime scene technician located a loaded 9mm Smith & Wesson pistol and a loaded SKS assault rifle.
Right.
Were those the victims' guns? Or were they, yes?
Yes.
And
Mr. Bright's testimony was they brought the guns in.
Were those the guns that were inside the house?
Yes.
And how did they then get outside the house?
Mr. Bright took them outside of the house. At some point, he also took the hammer that was inside the house out and
they didn't have anybody's, but they were never fired. Either
the 9mm pistol, and this supports the fact of the struggle. Mr. Bright's testimony that one of them had the gun, they struggled over the gun, and in fact, it was fired. There was a bullet hole in the wall that was about 15 inches from the floor. There was a powder residue marking on the carpet, and the expert said that the gun would have to have been within a few inches of the carpet at the time it discharged. It also put the trajectory of the bullet went through a chair leg and into the wall, which was all consistent that it was during a struggle over the gun that the gun discharged, which is consistent with what Mr. Bright said.
The positioning of the 2 victims really undermine struggle. Really, I mean, from a common sense standpoint, it appeared that they were both in reclined positions, seated, from the blood splatter and all those kinds of things, that the reasonable interpretation is they probably were seated.
Actually,
I know the argument, they fell, but I mean, let's stand back from that common sense approach.
As I recall the forensic evidence, Mr. Brown was still in a recliner.
Right.
And that's where most of the bloodshed occurred. It's not necessarily that he was always in the recliner during this process.
Well, they found behind it a huge puddle of blood.
At the point of bloodshed, that appeared to be the case. On the other case, other situation, Mr. King, there was bloodshed in different places, and in fact, the medical examiner, in describing some of the wounds to the body, said that he must have been in movement because of where the location.
What did that mean? Movement of arms or movement around the the room.
Movement around, and including being standing at some point.
I just didn't get that impression. I just didn't get that impression that it was like all over, the room and that kind of thing. I got the impression that while there was movement, what they were talking about is movement to protect from the blows. Is that an unfair, common sense reading of the evidence?
As to Mr. King, I think there was more blood evidence showed, even though it was in the area of the couch, it was still on the floor, and there was still, again, the medical examiner, as to Mr. King, was talking about he had to have been clearly in movement.
You're saying moving around the room then? Is that what you're saying, rather than movement to protect?
It was movement to protect, but I think the wounds also suggested more than that. But I would have to, again, I would direct you to that testimony.
What does the evidence show about blankets or some other covering in which the victims were wrapped?
There was one, Mr. Brown apparently did have a covering over him. He was in the recliner.
And he was kind of wrapped up in it?
Wrapped up, covered with it. Yeah.
Are you suggesting that does evidence show that he was struggling with both of these victims at the same time?
We have evidence of a struggle. We have Mr. Bright's statements of a struggle.
Was he struggling with both of them at the same time?
He said that he was struggling with one came forward, he struck one, he tried to get away, he tried to use the gun again, but it wouldn't fire.
See, that's what going back to,
yeah.
I don't really see, there's something wrong with that picture, because the guns, if there's two young men who are ready to attack this defendant, how does he end up bludgeoning to death with I don't know, 56 on one and whatever, with a hammer, two people that supposedly are armed with AK, whatever they are, assault rifles and 9mm. It just doesn't, there's something missing here. I mean, missing to help your client, because it seems to me that he may have freaked because he thought they were confronting him, but after freaking, it's not like they were attacking him.
He in fact, in one of his statements said after the struggle and the attack, he lost it, and he did continue to beat the two individuals after they were down. But that was all part of the statement to, he made a statement to Mr. Lundy, his friend from the trucking company, and to another person that he knew who was in jail with him.
Well, again, can you just tell me, because I just want to understand the picture. He's 50, in his 50s, tall, short. I know there's something in the record about it.
There is something in the record. I don't remember there being a large discrepancy in sizes between these individuals.
But they were in their 20s?
They were in their, Randall Brown was 16, and Mr. King was in his early 20s, 21, I think.
And one of them was rather large, wasn't he? Wasn't 165 something big above?
Yeah, he may have been. Now, Mr. Bright himself is probably 6 feet tall. So.
Let me give a scenario that...
He was a Marine, all right?
I'm sorry?
He was a Marine.
He was a Marine. He spent 10 years in the Marine Corps.
Let's look at this person's life, his military service, which is significant here, his honorable discharges and his good conduct, and apparently a record of his life falling apart while he was in the military. And coming forward, and this was a frenzy, and that according to some of the medical evidence, it looked as though this individual, because of these, I mean, it was a lifelong kind of pattern.
Yes.
Tended to create paranoid tendencies. And I think we have to accept that these people are dealing drugs there, and the evidence is that he's trying to get them out and he can't get them out, and he becomes fearful of them for whatever reason. And I don't know, I mean, it may be that he's a Marine bruiser, but I didn't get that picture from looking at this. But on the night of this event, he just loses it, and he just beats them. And then the rest of everything, as we know, he says to whatever. Where would that leave us? I understand why if I'm a defense lawyer, I'm going to try to present this, struggle, and they're coming after me and it's self-defense and all that. But if I don't accept that, where does that leave us in the scope of Florida law and proportionality?
You're assuming, discounting entirely that there was a struggle.
Right. I accept the fear factor. I accept that. I mean, if I accept those factors, can't get them out of my home. I've got a terrible problem here. I've told my sister that, will you help me? And she's told, don't get involved here by the other two because you don't know what's going on. I mean, it's almost a threat to the sister. Assuming that's what we're dealing with.
With the given that we're discounting the struggle entirely,
yes, please.
Which I think is in the record here.
I understand.
I still think we're looking at a proportionality reversal because of the nature of, in this court and previous occasions, because we're dealing with the HAC factor here. That's what you're addressing. And
we seem to have cases on both sides of this. With HAC and a prior violent felony, we go different ways.
You go different ways. That's
and so, why have we gone different ways, and where does this case fit?
With the scenario here, often the severity of the manner of death has been an indicator or a reflection of the state of mind of the defendant. I know that we don't look at the defendant's intent or that sort of issue, but it's reflective of the mental condition of the defendant. Panicked, exploded, lost it. We have the doctor's testimony here that long chronic alcoholics frequently develop neurological problems and suffer from paranoid ideations. It could be, and in fact, Dr. Miller says it may have been likely that he perceived a threat where none was actually, or the intensity of one was not actually there.
I don't think that there's any evidence to undermine that these folks were involved with drugs and that he had attempted to get them out. Right. I mean, so we accept that.
So I think you can, in spite of the HAC factor, I think you can note that it is reflective of where he was in his mental state.
And so you see that as being the distinguishing factor in our jurisprudence with regard to ones that we have held proportional and ones that we have held not proportional.
I certainly think that is a factor.
Well, let's go through them. Because I think that's going to make the difference in your client, whether he lives or dies.
Then, again, this court on previous occasions has acknowledged that manner of death, severe beatings, compulsive acts, multiple stab wounds, have noted that it's frequently someone in a distressed mental state that does those kinds of crimes.
And in those cases, we've held not proportional. Is that what you're saying?
In those particular cases that I cited, it was dealing with the HAC factor, and some of them, yes, some have been reversed. I'm not saying we've got on fours comparables here, but we have just instances where this court has acknowledged that in spite of the horrendous nature of the manner of death, because of the defendant's mental condition at the time, that in essence it was a discountable event as far as the death penalty is concerned.
I'm sorry. Is that the only factor? That's what I'm trying to see. Any other factors other than the frenzy?
The frenzy, the panic, responding in anger. I mean, that's the nature of the crime here.
Well, no, I understand, but that's where we have sort of, you read our case law as that being the dividing point.
I've seen your cases that support the position that the HAC factor, the manner of the killing, this in an HAC situation, is reflective of the mental condition. Which
well, that could be like Crook. In Crook, there was a particularly violent manner of death. But here, you see, this is why, for me, the two victims. Tell me which cases we have reduced to life where there have been two victims that were killed in the course of the criminal activity. I can't think of any.
Where there were two victims that were killed?
Yes.
Yeah, well, this court has reduced to life cases where there was a prior, for example, you had two contemporaneous murders. Knowles versus State, cited in the brief. Contemporaneous murder. They were contemporaneous murders, and this court reduced it to a life sentence.
What were the circumstances in Knowles?
Knowles, as I recall the case, It was, again, the mitigation in that case was alcohol intoxication, and he had some neurological problems as a result.
And how did he kill the 2 victims?
I'm trying to recall that case.
All right, well, we can look at this. You see,
yeah.
I think this is why it goes back to the fact that the way these murders occurred, if there was a frenzied attack as he perceived that he was about to be killed, and then he bludgeons 2 of them. But I think that the record shows, as Justice Kennedy was mentioning, that they were not in a position, they were either reclining or asleep, one was wrapped in a blanket, whatever, that this alternative theory of what happened isn't really supported. And to me, you've got whether he lost it because he perceived this, because there is evidence that he was wanting to get them out of the house. Nevertheless, he ends up bludgeoning 2 young people to death when there were many other alternatives. And there's not even evidence that at the time that he was on a cocaine binge or intoxicated. And so, although I agree there's certainly mental mitigation.
Yeah. And there was evidence he was smoking cocaine that night, as well as he'd been drinking.
I thought, well, I got to, again, unfortunately, we have 2 back-to-back. I have to look back
there was evidence that he was smoking cocaine that night.
I just didn't see this as being one of these cases where the mental mitigation outweighs these very strong aggravators, which are HAC, the prior violent felony, and the contemporaneous felony. I mean, those are, and again, we don't just have a strangulation that takes place in a few seconds. We've got multiple blows. Now, you say, well, that's indicative of him losing it. I understand that. And maybe if there's one victim, you say, who had the gun, you could start to get there. But I'm having difficulty with your proportionality argument.
Your Honor, I have difficulty giving you a case, as I say, directly on all fours on proportionality, but there have been cases where you have reversed when there were prior murders. There have been cases where you have reversed where there have been horrendously HAC manners of death.
You say reduced to life?
Yes.
I just don't,
yes.
I can't think of one that's like this, where we've done anything.
I think you cited Penn v. State.
Penn? Yes, Penn.
1991, where he basically beat his mother to death with
yes,
a
that's
baseball
correct.
bat. And you had Kramer v. State.
Correct.
Where he beat another person to death, and the same 2 aggravators were there in Kramer v. State. And in both those instances, we reversed on proportionality.
Yes, that's correct. I do have those 4 cases.
Yeah. And in Penn, we struck the CCP aggravator. He had no significant history of criminal activity. It was a 1 aggravator case, and as it was a 4-3 decision of the court. And then Kramer, we said there was a spontaneous fight between a disturbed alcoholic and a legally drunk man. That's why I focused on the fight, about whether this is some spontaneous fight. And I think that Kramer was that kind of case.
We have, again, we have the physical evidence there. I don't think is inconsistent with Bright's statement that he made to more than one individual about there being struggle. What prompted the struggle? He indicated he was a bit vague. Other than being accused of stealing the drugs and then waving a gun around. One statement, he said they were waving the gun around. He tried to take the gun away from Mr. King, and then that part of the fight ensued. We're left with, the physical evidence on the scene and Mr. Bright's statements about what happened.
Is there any other evidence with regard to this gunshot being fired, and any other evidence that suggests that someone other than one of the victims was the owner or possessor of the gun?
There's no indication.
So what we have is some description, but we do have the gunshot residue and the bullet hole in the wall. Fresh?
And it's consistent with Bright's, yes.
Fresh?
Yes. And it's consistent with Bright's testimony about what happened. He said they were struggling over the gun, and he held on. It was a 9mm automatic pistol. And he held on to the gun, and when it accidentally discharged, it startled the young man who was hanging onto the gun, and he got the gun temporarily from him. But the firearms expert said an automatic pistol, if you were holding it and you were holding it over the slide mechanism, that would have prevented the slide mechanism from actuating and extracting the fired cartridge and reloading a new cartridge. And that was consistent with...
But it isn't what was the other person doing? You know, that's what makes this kind of incredulous, is what was the second person doing when the first person was being bludgeoned to death?
You know, we'd have to speculate.
Well, I mean, we have two
about how that struggle transpired.
Here who were bludgeoned to death, and I mean, certainly it didn't occur. I mean, it wasn't like there were two hammers. He was beating both of them simultaneously. Right. So what was the other? I just cannot understand how this could have happened unless these people were asleep. When he's beating one and the other one is what? Just sitting there watching?
My understanding is that one was asleep and was awakened by the commotion with the fight with the other one.
And so that's when he woke up. As soon as the other one wakes up, he starts bludgeoning him?
Again, we're having to... we know there's evidence of a struggle. We don't... I mean, the dynamics of what exactly went on, obviously, we don't have that.
How about victim
recorded.
Blood evidence with regard to... were they coked up, the victims? I mean, were they... I mean, is it...
Randall Brown had no drugs in his system. Mr. King had cocaine in his system.
Well, how much? I mean...
The expert said that it would have been recently consumed, recent to death, based on the metabolism rate of the cocaine found in the system.
Do you recall if originally this case was filed by information to counsel second-degree murder?
It may very well be. It's not an uncommon practice for the prosecutors in that area to initially file a second-degree murder count and then seek the indictment.
Counsel, you have used all your time. However, since we gave you so much help in the consumption of your time, I will give you 2 minutes for rebuttal.
Thank you very much.
May it please the Court. Meredith Carbula, Assistant Attorney General for the appellee in this case. Justice Lavarga, let me start with answering your question. Yes, the jury was instructed on second-degree murder as well as voluntary manslaughter, the correct voluntary manslaughter instruction. And there was no objection. I don't recall a specific request for the second degree, but they were instructed on premeditated only, second degree, and voluntary manslaughter, which is exactly the way it should have been. Next question. How tall were the victims and the defendant? Derek King was 6'5", 163 pounds. Raymond Brown was 5'10".
And his age what was his age?
20.
Okay.
Derek, 6'5", 163 pounds, 20 years old. Randall Brown, 5'10", 147, 16 years old. Defendant, 6'1", 180 pounds. I don't know whether this court has the color photos in this record. I've started talking to my prosecutors that it's really important to put those into the record for the clerk so she can send it to the court, because the color photos in this case tell a million words.
Well, the problem is we don't receive the original anymore from the trial courts after we had the experience of losing an original in transport. And so if we have anything, it's probably just a copy.
I would suggest that this court order them on disc, and that way, if the originals will still be in the clerk of the court, and you'll have a disc, and it's really easy to access them, because the evidence absolutely refutes his claim of self-defense. And this notion of a struggle, Dr. Aruza described what she felt a struggle as somebody hitting somebody and them trying to defend themselves.
How about the gunshot? I agree with what you're saying. As you look at it and everything else would appear a frenzied beating, But what about the gunshot?
Well, first of all, I want to tell you that there's no gunshot residue found on either of the young men's that died's hands. No fingerprints were lifted from the guns that linked them to the victims. We have to remember that, and also any notion that he was trying to get these two young men out. Lavelle Copeland was in jail, and he was actually Bright's roommate. And earlier in the evening, Michael Majors saw the victims in this case playing Mr. King was playing chess with Mr. Bright. All was well. They called out for pizza. This notion that he was trying imminently to get them out of the house is simply refuted by the evidence.
Well, I mean, but there's evidence from his sister and from others. I mean, this is like a Jekyll Hyde kind of guy as you look at this record. Is that when he's working and not fooling around with drugs and substances, that seems to be a normal, everyday Floridian, but then gets involved with these substances and becomes less than what you would expect.
I agree, and I think unlike many defendants that this court sees, he had many opportunities through the VA for rehab, and he failed. Stay clean for a period of time.
But he failed, correct? And there's an explanation for that. So I think it's important you go into that fight and struggle, though. I think that's important.
Well, this is why I want you to look at the photos in this case, because you'll see so let's start with Raymond Brown, and I think Mr. McClain has really admitted that there is absolutely no evidence he moved. He's found sitting with his legs over the arm of the chair. His head is up against the wall. He's covered with a blanket, and all the blood spatter is up against the wall, except where there's a void in one of the pictures, and you'll see that's where his head was sitting, his head was sitting over the blanket. Above him is a picture that has been hit by the hammer. The evidence is there's a hammer strike right in the picture, and the frame has been knocked off. So all that hitting is right there. He never moves. He's got a fractured arm. He's got a fractured jaw. He's got defensive injuries, and he never moved from that chair, and the physical evidence absolutely tells that story.
Is there any evidence that would indicate where he would have gotten the hammer from?
Well, I think it was his girlfriend who testified that there was they had moved the washer and dryer the week before and had, for some reason, used a hammer.
Did he have to go to another room to retrieve it?
He claimed that he tried to run out of the house and he fell, and the hammer just happened to be by his hand, and he picked it up. I don't know where the hammer was, and we don't know where he went to get the hammer. But what we know is that Randall Brown never moved from that chair, and he beat him on the top of the head, on the side of the head, methodically until he was dead.
Do we know if he was first or second, or?
I don't know, and I don't know. But what we do know also, I think Justice Lewis, you asked about the bedclothes, and that's another really strong indicator, is that Derek King, there's absolutely no evidence that he was ever standing up when he was attacked. Now, we have to remember, he's 4 inches taller than the defendant. Absolutely no evidence. Now, he did have a significant amount of injuries on the top of his head, on the back of his head, where it's clear he was down, but all over his head, but very focused on his head. And if you look at the photographs, again, where his body is found, it's like he was laying on his back and just rolled over, because he is found face down on the floor about that far from the couch. His shoes that he put there to fall asleep, apparently, weren't even disturbed. He just rolled right over them. There was no testimony of this gunshot, by the way, going back to your question, I didn't mean to forget, I'm sorry, Justice Lewis, is that it was fresh. It was in the door, there was gunshot residue. It was actually, Derek King was laying on top of it. But it's only his story that it was fired that day. We don't know that. But what we do know is there's no connection with the physical evidence connecting the victims with the guns. There's no fingerprints lifted from the guns matching the victims. There's no gunshot residue on any of their hands.
What about the defendant's hand? Any gunshot residue?
He was arrested about 24 to 30 hours after the incident, and I don't believe they found any. I don't know if they even tested, given the length of time.
What about his fingerprints?
No fingerprints on the guns. There was a pair of gloves found out where of mechanics gloves found out where the weapons were buried, and he buried the weapons and the magazines under leaves, and he buried the hammer deeper, and that's why they didn't find it the
Speaking
first time.
of the two victims, you're saying that it appeared, I mean, that no movement at all. They just were bludgeoned and just rolled over.
Exactly.
Well, then does that mitigate against HAC? Is that there's an instantaneous death there? There's no struggle at all.
Oh, Justice Lewis, the victims, both medical examiners testified they had a lot of defensive injuries to their hands.
Okay, that shows that there's movement then.
Well, movement.
Well, I
like
understand.
this.
Okay, well, that's what I'm saying. There is movement. It's not just they roll over.
No, but when I say movement, I mean they weren't moving
Okay.
throughout the house. I mean,
Okay.
yes. I mean, Derek's nose was broken. His eye was broken. He had defensive injuries from his hand up to
That was my
shoulder.
understanding that there was. It appeared that something was going on, but then you described it as though sitting in the chair, never moving, and then on the couch, never moving, just rolling over on the shoes.
I apologize. I intended to say there's no evidence that he moved throughout the house.
Okay.
In fact,
triggered this?
I don't know. The state did not offer evidence of a motive at trial. And, you know, I think consistent with this court's admonition of prosecutors should not create imaginary scripts, the prosecutor refrained from doing so.
But I think that, again, if we take what's logical, and I understand a lot of our murders are not logical, but as far as in this defendant's mind, is that the evidence is uncontroverted. He wanted these two, they were drug dealers.
No, ma'am.
They were not. Okay, so did he want them out of his house?
I don't know, because he was playing chess with Derek King in the day. They called out for pizza. I don't know the answer to that.
Is there not evidence of him going to the police about this?
Lavelle Copeland was the one living in his house, paying him rent with drugs and money. Now, Derek King knew...
I'm sorry, what was that name?
Lavelle Copeland, and Mr. Copeland was in jail at the time of this murder.
So these two are not the two people who lived with, renting from him?
No. Now, Randall Brown is just a visitor. He is an associate, a friend of Derek King.
One of them didn't live in the house?
Now, there was evidence that Derek King and Lavelle Copeland were close, that Derek King lived, that visited often, was there with Lavelle Copeland, but Michael Majors testified that Derek King actually didn't live there. He lived with his Majors' grandmother, but there certainly was evidence that Derek King was there at the house very often. And whether he stayed overnight with Lavelle Copeland, I'm not certain. But Michael Majors, who testified directly on, he was asked, does Derek King live with Bright and Copeland? He said he doesn't believe that. He lives with his grandmother.
Well, I guess I thought that, and maybe this was the defense, but it seemed credible, that he perceived a threat from, not contemporaneously, but had perceived a threat, wanted them out of the house, and he also perceived a physical threat. Now, the guns, whether they used it at the time or not, is it uncontroverted the guns were theirs, or is that...
It's not uncontroverted.
Okay.
I don't know who the guns belong to. I think Mrs. Brown testified that she'd never seen her son with a gun. Whether the guns were in the house because they belonged to Lavelle Copeland, or
Were
whether,
any of the people that are drug dealers?
Well, I think there was some suggestion that Mr. King may have been, but because he was associated with Lavelle Copeland and he regularly, but you know but again, this notion of and I don't dispute that Mr. Bright wanted Lavelle Copeland out of his house, but
All right,
Lavelle
that's
Copeland was not there at the time.
So he wanted them out. So he wasn't, but he was the one that wasn't there.
Mr. Copeland was not there. But what I'm saying is, and I think it would be reasonable for anyone to want somebody out of their house or if they're dealing drugs, but what I'm saying is that day of the murder, the only evidence we have of Mr. Bright's association with King and Brown was it was a very friendly encounter. They were playing chess, having pizza,
So in terms of this
hanging out.
making this why the mental mitigation becomes very important, is because you've got somebody, former Marine, honorably discharged, has struggled with cocaine, drugs a lot of his life, and he admits afterwards, I did something terrible, I lost it. Now, why isn't this more like a a Donnie Lee Crook case of a horrible murder, but someone losing it, and that the mental mitigation is so strong that it warrants a reduction to life.
Well, first of all, I think with the physical evidence showing that the young men were asleep when the attack started, controverts this notion of a frenzied attack losing it. But I want to point out...
That's not the frenzied attack is the extent, the nature of the terrible beating. That's the frenzy, not when it occurred. It's just how.
In other words, in Crook, I mean, she wasn't a threat to him. The whole point being that at times, and they're not most of these murders, that it's so senseless. It's not for money. You heard the prior case about wanting the house, an elderly victim, targeting him, taking money, going to take his house, that this is his house, and he could say, please, I don't want you in my house anymore. But bludgeoning them where there's no attempt, he leaves them there. He doesn't. Does he do anything with the bodies?
He doesn't. He leaves them there. He disposes of the weapons. He disposes of the hammer. He goes to his ex-wife's home. He disposes of his bloody clothes.
Well, she disposes of the bloody clothes. She gets worried about it, but he tells her, I did something terrible. He doesn't really, there's no way he thinks he's getting away with this.
Right, correct. He starts, I think, setting up his self-defense right away. But I think
going back to the victims being asleep, I mean, in Pan State, Pan beat his mother to death while she was asleep with a baseball bat.
One of the things in Penn was it ended up being a one aggravator case, was ASAC. And also there was evidence that Penn's wife had told Penn that Penn's mother, Penn was estranged from his wife, I think, in child, but definitely from his wife. I don't right this minute recall whether he had a child. But Penn's wife had said, your mother's the one standing in the way of us getting back together. So, and of course, subsequent to Penn, this court has really repudiated any notion there's a domestic violence exception to the death penalty. But I think that we have here this issue where mother was supposedly standing in his way, and it turned out to be a one aggravator case.
Have we ever reduced to life in a case where there were two victims at the same time that they killed? And not one.
Mr. McLean said that he thought the Knowles case was, but that was in a string cite, and I can't remember the facts of that case. But I did not find one personally during my research. But I want to go back to this mental mitigation evidence first.
Before you go on further, you were making the point that it was only the person in jail who was actually in the home. What was the testimony, though, to the individual who tried to intervene to get these people, as I thought I read the record, people, not just one person, out of his house?
His sister testified that they, sometimes prior to the murder, Lavelle Copeland was supposed to be out of the house sometimes in March. He was given Mr. Bright supposedly gave him an ultimatum to be out in the house of March. Of course, this murder happened before then. His sister tried to intervene to get Lavelle Copeland. She called Lavelle Copeland and said, my brother wants you out of the house. So all that testimony
relates only to the fellow who was in jail at the time. Is that what you're saying?
No, Justice Lewis. What I'm saying is that Michael Majors testified that King, to his best of his knowledge, King did not live here.
I'm talking about the conversation that the sister had, and they told her, get out of this because you don't know what you're getting into.
Right, that was Lavelle Copeland.
That was Copeland.
Exactly.
Okay.
And again, I think it is disputed whether King was staying frequently over there with Lavelle Copeland or not. All I know
Tantamount to living there.
All I know is that
Is
Michael
that correct?
Majors...
Tantamount to living.
I
May
don't
not
know that, Justice Lewis. I honestly
What's
don't.
the evidence? Come on, you've always been straight with it. What's the evidence?
I'm trying to. Michael Majors said, to the best of his knowledge, King did not live in the home, that he lived with Majors' grandmother. But I think there's certainly a suggestion that Derek King stayed at the house with
Quite
Lavelle
often.
Copeland
What
on a regular
was
basis.
Michael Majors' relationship to Lavelle, and was he a friend also?
Michael Majors was primarily, he would go over to visit Lavelle Copeland, and that's why, that's where we have evidence that Derek King was over there frequently, too. And the only thing I'm not trying to fight with you, Justice Lewis. I'm just saying.
I understand. I understand.
Michael Majors was asked specifically the question whether Derek King was living there, and he said no. He believed he was living with Majors' grandmother at the time. However, there was also evidence that King was there very regularly. So whether he slept over regularly, I just don't know.
That's fine. We need candor when we talk, and your reputation is one of the most important things you have in this court. So.
Well, I agree, and I'm trying to tell the court what the record says.
I accept that.
So I'm not disputing that King was not there often. I think the record supports that. I'm just saying that whether he was formally living there was certainly not clearly established, but I think the evidence shows that he was there regularly. I'd like to go to talk about this.
Now, if going back to that, now, if King was there to visit Copeland and Copeland's in prison, he must have felt comfortable staying in the house.
I agree.
About his friend being there.
And I agree. And as I say, the evidence showed that Mr. Bright was playing chess with him. They called out for pizza. So there was social interaction there, which Michael Majors did not interpret as hostile in any way.
So these two guys were friends of Copeland and not Bright?
Correct. It appears that the visitations of the house, including from Michael Majors, were primarily they would go over and visit with Lavelle Copeland. And Bright was not there very often, but on this occasion he was. So again, I think the evidence supports a conclusion that Derek King was there very regularly, but Randall Brown not.
How is this proportional if the evidence says this guy just lost it all of a sudden without any apparent motive?
Well, of course, I think it's speculative to say that he lost it. I mean, he managed to bludgeon to death two men who are 30 plus years younger than him, and in where they sat, and his, I don't think we're talking about a frenzied attack because there's not evidence of body blows or anything. I mean, everything was targeted to his head, and he was someone who is a former Marine. He was kicked out of the Marine Corps in 1983, but he was a former Marine, and he put the blows on the head to kill these victims. And so I also want to go back and when you
we know he killed the victims, and we know he did it using a hammer. You said there was no, state advanced, no apparent motive. And I agree we don't have to have a motive for every crime, but there are cases where a lot of them are motivated by wanting to get drugs or get money or whatever it might be. It's therefore the issue that I have and just going is that it is a inexplicable crime unless he lost it, and that still may mean it's proportionate. That's what Justice Paulson says. Let's assume he lost it. He lost it because he perceived a threat to him. Okay, he lost it. How is it? Explain why it's still proportionate.
If the evidence, I mean, the court found in this case two aggravators. Dr. Miller, there was absolutely no evidence he has any kind of mental illness. His mitigation was, except for his Marine Corps service, which was 25 some years, ended when he was kicked out of the Marine Corps 25 years before the murder, was minimal. He's got an average IQ. He had prior violent felony with an armed robbery.
Now, was that, let's just go to, because there are felonies and prior violent felonies. Is it correct the way this was described? That is, he brought a knife in and did not injure, just demanded money, and a police officer was right there, and he got probation for it?
The police officer saw it. I'm not sure whether he was outside.
Did he get probation?
He got probation. He
and he had
his
a knife. What kind of knife was it?
It wasn't clear in the record.
Well,
what kind of
it's
knife.
not like an arm. It wasn't. I mean, it's a robbery because there's a knife, but it must, whatever it was. And what year was that?
90. I think he was convicted in 1991.
Yeah. To get probation for a robbery, it could not have been much of a robbery. Would you agree with that? I mean, usually people get, a pretty long sentence. So even though I said prior violent felony counts, this one doesn't seem to be in the scheme of prior violent felonies, very significant. Let me ask you, if the prior violent felony aside, having 2 murders, which was Knowles in 1994, is it what the judge says, that HAC, because the 2 murders are both HAC, so it's 2 murders plus 2 HAC, that's distinguishing it from a case where this was a single murder HAC?
Yes, the trial judge did say that he relied heavily on the HAC aggravator, and
doesn't in this kind of case, because HAC, it started out as something where there was an intent to torture, and we've changed, it's morphed into situations where somebody strangles, or certainly here. Especially if one of them was sleeping, it doesn't. And I understand that HAC doesn't need an intent to torture. It's from the point of view of the victim. But is this how long did each victim remain alive before they lost consciousness?
There's no evidence of that. What we do know is that there was sufficient time in which they were defending themselves.
And I appreciate that we find that's why I said when we say it's the most weighty aggravator, I mean, it can occur if someone starts strangling and again, not to minimize it, but it's, it occurs, like, the last case was the guy, he shot him. This defendant, if he was really just trying to kill them, he had the guns, he could have shot each of them, not blood, so again, it goes more to me that this is a spur of the moment, senseless attack. But you're saying that the mental mitigation is not substantial? Is that
it's not substantial? Dr. Miller said he was of average intelligence. He saw no cognitive deficiencies. There was no major mental illness diagnosed. Dr. Miller did say that there were, physiological effects and neurological effects of drugs and chronic use of drugs and alcohol, but he never diagnosed Bright with any of those. So the trial judge found one mental mitigator, gave it some weight because of the chronic drug use. But Dr. Miller did not opine that either mental mitigator was present at the time of the murder, and the rest of his mitigation, I would submit to you, is minimal. I've struggled with trying to find a motive. I mean, the prosecution's at least working theory is that Mr. King had some money in his shoe and some marijuana in his shoe, but not a bit of crack cocaine was found in the house. So I think the state's working theory prior to trial is that Mr. Bright wanted that any crack cocaine, but because there was no evidence of that, the state again did not try to create an imaginary script.
The prior violent felony was a robbery in 1990, according to the panel's brief, in Pensacola, and apparently he used a knife to threaten the clerk at the convenience store.
Correct.
And unfortunately, he committed the crime in the presence of a police sergeant. Not a good thing to do.
No, as I say, I don't know where the police officer was located at the time, but
he witnessed it, according to
whether he was outside the store, whether he was a customer in the store, I don't know. But yes, it was one of those unfortunate things that happen that you do it right in front of a police officer. This court has upheld the proportionality of this cases. Again, we have no major mental illness, we have no low IQ, we have no evidence of brain damage to this defendant. We have HAC, and we have the prior violent felonies. Now, just briefly, I'd like to talk about the prior violent felony. First of all, this issue is not preserved for appeal. This is one that could have been easily fixed had the defendant raised this below, and once a sentencing order was issued and said, hey, you can't consider this prior violent felony separately, so it wasn't preserved for appeal. And it's kind of funny. It almost seems like it possibly could be a super scrivener's error, because in every other place in the record, the court referred to two aggravators, one prior violent felony, one HAC. He instructed the jury there were 2 aggravators. The written jury instruction says there were 2 aggravators, and during the oral pronouncement of the sentence, he said, well, I've found and considered 22 mitigators and the 2 statutory aggravators. And somehow in his written order, he put them 1, 2, 3, and referred to them one time as 3. But every other place in the record, it was 2. And so I don't think we even talk about harmless error because it's not preserved. But I think it's certainly harmless error when given that the trial judge can consider this escalating, or the fact that he's got a prior violent felony and he's also got the contemporaneous murder. So we don't think that it's preserved, and so the harmless error analysis is even appropriate. But even if this court would overlook the failure to preserve, the state's position is that it's harmless error. And I think the court should look at the cases like Way and Smithers.
Wait, Way?
Way.
Mr. Way, who committed arson and killed his wife and daughter in a calculated way. He put his house on fire. I don't see that as being, we always have to be careful that when we're trying to qualitatively review these cases, we don't go, okay, there's 2 similar aggravators. That was horrendous, planned arson. He knew his wife and his daughter were in the house.
Well, actually, what he did was he called them out to the garage and he beat them over the head with an instrument, and then he set the garage, and then he burned them in the garage on fire. CCP was found but not considered. It was the mitigation, and the reason why I pointed out Way was because Way, like Mr. Bright, had military service, and the mitigators were close, as well as the aggravators were close, and Mr. Way had no significant criminal history, while Mr. Bright did. Another case I think this court could look to is the Smithers case, and in that case, both mental mitigators were found. It was 2 victims. He beat them, strangled them, choked them, and those were actually done a few days apart. But Smithers had no prior violent felony. Bright did. Smithers, the trial court found both mental mitigators, in this case only 1, and gave it some weight, not because Dr. Miller opined that they applied, but because of the chronic drug and alcohol abuse. And Smithers had a brain damage and chronic mental illness, while there's no evidence of specific brain damage attributable to this defendant, and no evidence of chronic mental illness.
What was the jury's vote? Was it
8-4?
8-4.
On both. And so I would submit that perhaps Smithers is closer, but Way had the honorable military service and similar non-statutory mitigation.
I guess that's why I say you can't look at these cases, because to me, the idea that you're going to then ask your wife and daughter to come out, and then you're going to methodically bludgeon them, and then put the garage on fire. I know he contested whether he actually committed the arson. It's just not this case. So
I understand, and that's why I try to address those proportionality, and in each case is different. And I thank the court for the time. I see I'm out of time, and so based on the record, state would respectfully request this court affirm the conviction and the 2 death sentences.
Thank you for the extra time, and I'm going to talk fast. On the doubling issue, this court's never required preservation of a doubling problem with some post-sentencing order objection in order to raise it on appeal. In fact, when the Appeals Reform Act came out and the 3800B motions, capital cases was specifically exempted from that provision, saying it wasn't necessary. I would also point out that, yes, King routinely stayed at the house. The suggestion is he routinely stayed at the house, even though Mr. Copeland may have been the primary actor in the drug dealing operation. Randall Brown definitely did not live at the house. He was merely visiting that night. In the Penn case, Mr. Penn did in fact use a hammer when he killed his sleeping mother, and he was also a cocaine addict at that time, and he was actually stealing stuff from the house in order to give to his cocaine dealer. I know I'm sporadically going over here. One point on the autopsy on Mr. King that suggested that there was a struggle was among the, even though there were defensive type wounds to the arms and hands, he also had fresh abrasions to his knees, which would be consistent with a struggle. I'll try not to take any more time. Thank you.
We thank you. We thank you both. The court will now stand in recess for 10 minutes.
All rise. Please be seated.
We now come to the third case on our docket, Keck versus Eminisor.
Good morning. May it please the court. Howard Maltz on behalf of petitioner Keck, and I am reserving 5 minutes for rebuttal this morning. We're here today because Mr. Keck claims immunity from suit under Florida Statute 768.28 paren 9A and seeks certiorari review as a result of the trial court's denial of his summary judgment. The first DCA denied that certiorari review on the grounds that he has not or had not suffered irreparable harm. In fact, Mr. Keck hadn't suffered irreparable harm because he claims immunity from suit.
Well, because, and I realize what your argument is, what I want you to explain is how this case is distinguishable from the Department of Education versus Roe, the Roe case, where we specifically said that unlike qualified immunity, that these types of immunities of governmental entities would not be reviewable. And I realize it was a question of declining to adopt a rule similar to Tucker, but really the underlying case was brought as one of cert. What would you say is the distinguishing factor? Because I agree with you that should not be whether it's discretionary or this is just a bus driver. Would you? And maybe I'll tell you what I think. The difference is that this defendant is being sued in his individual capacity, and the statute specifically says that he should not be named as a defendant. I mean, assuming he's a governmental employee, as a defendant in a lawsuit.
That's exactly correct. That's the distinction between this case and Roe. Roe involved a suit against a governmental entity, the Department of Education, I believe, that was claiming sovereign immunity and sought interlocutory review of their denial of the sovereign immunity. This is an individual who has a statutory right to immunity. There's interesting language.
Again, is it because he's an individual and therefore subjecting an individual to a lawsuit is different than subjecting a governmental entity to a lawsuit?
Absolutely, and that was some of the language from this court in Roe when the court the court indicated that some of the policy concerns in Tucker when an individual governmental employee is being sued are not present when the entity itself is being sued.
On the other hand, if you read Roe, what we say is, for example, public officials who defend tort suits are not sued in their personal capacity. As a result, defending these suits is not likely to have a chilling effect on the exercise of public officials' discretion in the discharge of their official duties. So I would think that what the First District picked up on is that here you have a bus driver who's driving sort of an ordinary negligence situation. It's really not the kind of discretionary planning level things that we worry about is going to interfere with a public official who's otherwise spending their time having to defend a lawsuit.
Well, the First District became confused with the standard for qualified immunity under 42 U.S.C. Section 1983 and the individual governmental employee's immunity in 768.28. For qualified immunity in Section 1983, the governmental employee must demonstrate that he or she was engaged in discretionary functions. Now, the 11th Circuit has defined that to even mean ministerial functions. But I believe that's where the first DCA got confused. Going back to the issue of Roe, in the second to last paragraph of the Roe decision, there's a discussion by this court of the Mandinko decision, and it talks about the amendment to 9.130 for workers' comp immunity. And there it said there was a statutory scheme that created the exclusive remedy in a workers' comp or an injured employee situation that the employee only collects comp benefits and cannot sue the employer. You have the same thing here.
But what happened to Mandinko? It's now the rule that allowed interlocutory appeals has been repealed, and we've never once acknowledged that those cases can be brought by cert. And my concern here is this case is a discrete case. I'd say, well, there's a matter of law, that we can look at. But what we're looking at is the appellate courts their cert jurisdiction as opposed to non-final appeals, is something that we got to carefully consider. And so every immunity has the potential that they're going to be held into court. And so the question of what you distinguish, is it individual, you've got judicial immunities, you've got the tribal immunities, and then you've got that whole host of sovereign immunity, which now the 3rd District has said those, even if it's against a governmental entity, they should have cert. So we're in a flux in our law, and I think this is therefore an important case, not just because for your individual client, but for the idea of what should be the use of cert in these cases where we very carefully looked at cases, venue, you get to bring it. So would it be better then, rather than trying to expand or contort cert, to take this like we did Tucker and say this class where it's an individual is being sued who's not even subject to being a defendant ever, should be reviewable by non-final order?
Yes, we surely would welcome an amendment to 9.130 that would include this class of defendant, where an individual public employee is being sued and claims immunity under 768.28, and that immunity is denied as a matter of law where there is no factual dispute. We clearly would welcome that rule change. Even if this court were not so inclined to move towards a rule change, I do believe that Mr. Keck nevertheless would be entitled to cert review here.
But do you agree that what I said about Mandico, that we've never once authorized a review of workers' comp immunity by a petition for writ of cert?
I believe that's correct.
And in fact, in Mandico, we specifically said a prohibition will no longer be available.
Absolutely. But in Mandinko, there was that discussion, or actually in Roe, the discussion of Mandinko. It talked about the statutory, comprehensive statutory scheme which created the exclusive remedy. You have the same thing at 768.28.
But that's why I say, but we didn't, it's what it is, but then if you use it, we've never, it goes back to my question, but we've never acknowledged or recognized that cert review would be available for a claim of workers' comp immunity.
Correct. But I think in this situation where you have individual immunity, someone who has suffered that irreparable harm because they can't get that review after trial, they cannot get re-immunized after trial.
Well, they can get, the issue, they won't ever have a judgment against them. There's two types of the issue of harm. One is you have to be sued. I always think of Clinton versus Jones, don't worry, he doesn't have to worry about it interfering with his official duties. He can go ahead and be deposed if you're, the U.S. Supreme Court case. But here you've got a situation where there's two, one is not having to go through a trial,
right.
But the other is you don't get a judgment against you. And that's probably from the individual's point of view, that's the most critical thing, is that they don't have a judgment entered against them. Well, and they're still able to preserve that after trial.
Of course, that's important to the individual, but the Florida legislature has specifically spoken and said they should not even be standing trial. They should not incur the expenses.
No, I think that's, like I said, I think that's a good distinction from Roe, and I am, I understand that. And so how would the rule of law then read as to petitions for cert? What would we say? That irreparable harm is established when?
When an individual claims immunity from suit under 768.28 paren 9A as a matter of law and there is no factual dispute.
So it was so there you're getting into, though, see, it's still irreparable even if there's a factual dispute. It's just not capable of being decided at that time.
That's correct. If there's a factual dispute as to whether or not they were within the course and scope of their employment, or whether or not they acted in bad faith or willful wanton and do not fall within the confines of that statute, a jury's going to have to decide that.
Well, there you don't have a departure from essential requirements of law, probably because you can't determine what the facts are to be able to say that there was that kind of error.
That's exactly correct. And that would not be the situation that would be facing the district courts of appeal on cert, where there's such...
Was there a factual dispute here as to whether or not his employer was a state entity?
It's not a factual dispute, it's a legal dispute. The facts here are indisputable. Actually, on page 16 of the respondent's answer brief, they acknowledge that Mr. Keck's employer, the Jack's Transit Management Corp., is an instrumentality of the JTA. So it is a legal issue as opposed to a factual issue with regards to whether Mr. Keck falls within the definition of a state employee, or more specifically.
What did the trial court say?
The trial court, in a departure from the essential requirements of law, in my opinion, said that the JTM, the employer of Mr. Keck, does not fall within the definition of state agency or subdivision in subdivision 2 of 768.28. We strongly disagree with that. The JTA in Florida statutes 349.02 and 349.03 has said the JTA is an agency of the state. The trial court found that the JTA is an independent establishment, and even if the JTA were an independent establishment, I think that this corporation acting as an instrumentality of it still would fall within that definition of state agency or subdivision.
Now, he gets his own, I mean, going to that second issue, I was interested in the advantages that employees of the bus company, the public bus company get, which is they get a private pension, and they get private unions. What happens when all the employees have to suffer like we have had to percentage decreases in our pay, all of those things? Does that apply across the board to these employees, or they have their own ability to negotiate their contracts?
Yeah, I don't know the status of their pension benefits. Whether
it's hard to feel as badly for these private, I mean, they want to be private for some purposes, but then public for others. Isn't that what the judge really was finding?
Yes, but in fact, the legislature, by including within the definition of state agency or subdivision in paren 2 of 768.28, includes the definition, or includes within the definition, corporations acting primarily as instrumentalities of the states, counties, or municipalities. Employees of those corporations, by definition, are not going to be eligible to be in the state pension plan, and likewise would have the right to strike and whatever private employee benefits that they might have. But nonetheless, the Florida legislature included the term corporations acting as instrumentalities of the state agencies within the definition of state agency or subdivision.
Now, they make a statutory construction argument, though, that since the employer that's one step removed. They're not an employee of JTA, which is a instrumentality, or they're the employee of the next step removed. Can you address that? Because
sure.
I thought that I'm trying to understand that, but you.
Sure.
Needs to help
what the respondent argues is that the JTA is not an agency of the state of Florida, but an instrument or an independent establishment of the state of Florida.
Do you agree with that?
No, absolutely not.
So that's the first issue of law that we would have to, I mean, that's an issue of law to decide what they are? Yes,
it is a question of law, and I do not agree with respondent's position on that. But even if the respondent were correct that the JTA is an independent establishment of the state and not an agency of the state, contrary to what the legislature said in Chapter 349, but even if the respondent was correct, if you look at the statute, the paren 2 of 768.28, it has three specific subparts, all separated by semicolons. The first one, which is what defines the state for purposes of that statute, is the executive departments, the legislature, the judicial branch, including public defenders, and independent establishments of the state, including state university board trustees. So even if JTA was an independent establishment of the state, and we're not saying they are, but even if they were, a corporation acting as an instrumentality of the independent establishment of the state would nevertheless fall within the definition of state agency or subdivision.
But then there's, okay, so if they're an independent establishment, and then are you saying that your client's employer was an instrumentality of the independent establishment?
Well, I'm saying that JTA is a state agency,
I know,
but if I buy
go-
their argument, then he would be an employee of an instrumentality of an independent establishment, correct?
If we're having some difficulty figuring this out, now you go, no, it's clear, but just let's say I'm going, I'm not sure about this. Is there any precedent on this subject?
There is one case out of the 2nd District called Pagan versus Sarasota County Hospital District, and that clearly was an independent establishment of the state. It was a hospital district created by the state. And in that situation, there was a corporation created, I forget the name of the corporation, but it was a corporation created for the purpose of employing physicians so they could still have the income of private practice but be protected from medical malpractice lawsuits. And in that case, although it didn't dig down into these issues of statutory interpretation and it was a question of control, but in that case, the 2nd District concluded that the employees of that instrumentality of the independent establishment were entitled to sovereign immunity protection.
I guess what I was getting at is how is this, an ordinary statutory construction argument, a departure from the essential requirements of law, which have to concern itself, because it's cert, it's an extraordinary writ, with something more than mere legal error? In other words, we buy that you got the first prong.
Right.
The second one, though, is it's different. That's why it's an extraordinary writ than just, well, you might be right, you might be wrong. There's two views of it, and therefore, how do you get to, without perverting departure from essential requirements of law?
Well, there is a statute here that confers upon Mr. Keck immunity from suit, interpreting these statutory provisions.
Well, and I agree. If this was
Right.
an ordinary employee of the state that had just been sued, and there was no other, he wasn't acting in bad faith, there's no question. But what I'm saying is this statutory, aren't we construing something for the first time? And I don't see how that is equated with the departure from essential requirements of law.
I believe when the trial court interprets a statute in this situation erroneously in such a way that denies somebody immunity from suit, in my opinion, that's a departure from the essential requirements of law. I see that I'm running out of time and cutting deeply into my rebuttal time, so I'll sit down at this point, and thank you.
May it please the court, good morning. I'm Steve Padgick on behalf of Ashley Eminisor. And on the question of jurisdiction, we have actually adopted the same position as the city.
I'm surprised about that. I think there would be a lot of plaintiffs' lawyers around the state that might be upset with you for conceding something that hasn't been decided by this court.
Yes, I understand. And we have to represent the best interest of our client. And the best interest of our client really is to try to have this resolved. Our client would like to have this resolved too. It's been 6 years since the accident happened, and it could be another 6 years if where there is an important question of law here that had only the Pagan case really, in the opinion itself, in the concurring opinion, we even say, as Justice Kennedy said, we're not getting to public policy issues, we're not getting to a lot of other issues under 768-28.2 because they weren't raised. This really is an important question of law that this court should decide, and on behalf of our client, we would like to have a ruling, and our client would like to have a ruling so that we could.
Well, I mean, you certainly are a well-experienced lawyer to know that a concession of jurisdiction, if the court has no jurisdiction, is meaningless.
Well, when the court has, I think there's the Tillman case that says once the court has accepted.
I mean, the jurisdiction of any court to entertain a certiorari petition under the circumstances, not here, but below.
Yes, sir. Yes,
so
sir.
just because you want it doesn't
yes,
mean
sir.
You're going to be affecting thousands,
yes, sir,
possibly thousands of other situations with what certiorari jurisdiction really is, and because it's discretionary, it becomes a monster. Why would it not be better, if you want to get a review of these cases, let's just have a rule. Let's just have a rule like we do the interlocutory appeals, and there's no differences from district to district, and it's simple, it's concise, it's to the point, and we can review immunity issues in that fashion.
It would be good to have a rule, Your Honor. I would concede that.
Well, would it be, I mean, and that's something, though, I think we got to look at, because these are coming up all the time. We have one from the 3rd District, I don't know if it's here yet, where all of a sudden courts are starting to use cert to circumvent the non-final order. If this is so important to the state that they not have defendants coming in, I mean, being brought into court when there's no legal right to do so, then we ought to have that class of non-final orders. Let the courts, as Justice Lewis says, do this in a uniform way, where then we don't have to worry about a fiction of departure from essential requirements of law. It can be reviewed, as was said. And I guess what you're saying is you wouldn't be opposed to that, but we'd certainly have to make sure that the impact on the appellate courts is not unduly burdensome, because there's a lot of these cases.
Yes, I would not be opposed to such a rule. We would, once the court, in this case, once this court...
We understand.
Yeah,
I understand.
okay.
We certainly accept
I understand. And I say that...
You would want to get the benefit of that rule.
Yes.
Which
yes,
happened in
yeah.
the 2 cases where a rule was adopted. They actually gave them the benefit of those rules at the time. And I don't see, and again, I do see a difference between individual immunity from where you can't, again, here's, I guess we go to the second point. You cannot name this person as a defendant. If this was somebody that was just an employee of the Department of Transportation, right? And you can't even name him as a defendant, correct?
Correct.
All right, so now I guess we get to your point about why isn't he just like a employee of a school board, Department of Transportation, any of these myriad of entities that don't, that the state says, no, you cannot bring them into court?
Because he and his employer are too far removed from the essential functions of government, from state government, from county government, from local government. They are far removed. And now, but it's important to remember that even under the common law, because this gives us a rule of construction here, even under the common law, state employees, public employees, had no immunity for tort. That's the Talmadge case, Justice England's opinion in the Talmadge case back in 1980, and that was the same for proprietary entities such as JTM is, and that's the Swanee versus Golden case back from 1952 at the Supreme Court. And
well, let me ask you this.
Yes.
Would you concede that if the defendant were an employee, and I'll make sure I get the acronym right here, of the JTA, directly an employee of the JTA,
absolutely,
that he would be entitled to this?
Yes, sir.
Immunity?
Yes, sir. And
well, okay, so the JTA gets the immunity, and their employee get whatever immunity they get from sovereign immunity, and their employees get
correct.
Immunity.
Yes, sir.
But isn't the reality, based on the facts that are undisputed here, is that he is functioning essentially, totally under the control and at the beck and call of the JTA?
We concede control is totally with JTA, but this is a separate question.
Is he paid by them?
No, his paycheck comes from JTM, I believe, and he's hired by JTM. JTM is set up there for, JTM is set up solely, it's a sham. And for the courts of the state to really support this sham arrangement where they just have a corporation, back when this was a bus company, it was private, and it was bought by the city, and when they bought it, part of the deal was, well, you've got to set up a private corporation so that our bus drivers can continue to strike and can continue to have their own private pension. And so we've got this sham arrangement. But as the court said in the Gulfstream case...
But the fact that there is that arrangement for purposes of the labor law and for those other reasons, why should that affect the ability of this... this individual employee not responsible for that. I mean, he's just doing his job, driving a bus. Mm-hmm. And then and maybe he was negligent, maybe he wasn't. That's something you can have an argument about. But if he was negligent, doing his job, driving a bus, why should he get individually dragged into court? When any other public employee An employee working for a public entity would not be dragged into court.
But he's not working for, that's the important thing. He's not any other public employee. He's not working for a public entity.
Who did you, besides him, who did you sue?
We also sued JTM and we also sued JTA. JTM did not, the petition was filed on behalf, petition for cert was filed on behalf of Keck, I think maybe the individual bus
So
driver.
who is being sued as the employer of Keck?
The employer of Keck is JTM. That's, JTA is an independent authority, an independent establishment of the state, half appointed by the governor, half appointed by the mayor. They're referred to as independent authorities.
Well, it looks like this whole area, I mean, we're in an era, every time I pick up the paper, we're privatizing some other government activity. And we're really headed for a real disaster if we get into this certiorari with every relationship that's going to exist in the way that I see this tide flowing.
Yes, I agree with that, Your Honor. But I also agree we're headed for, and we are getting this tremendous expansion of governmental immunity because of the wrong interpretation of 768.28.2, which we're allowing there to be steps and steps, further steps removed from what true government employees are.
Well, let's say, okay, so who is the corporation primarily acting as an instrumentality of the state? Which entity is?
Well, the alleged corporation primarily acting as an instrumentality of the state is JTM, not JTA.
And
JTM and the state. You notice here it doesn't say state, and it doesn't say, again, independent establishments of the state. It says state, counties, and municipalities. And not being repeated, you don't have that, these are the people that have immunity or limited liability, whichever way you want to look at it here, and those are separate questions, but it's the state, which is the judicial, executive, and legislative branches. It's counties and municipalities. There are also independent establishments of the state that have immunity, and there are also corporations who are primarily acting for the state and for the county and for municipalities. What they want to do is say, okay, we'll put this corporation out here. It goes to the independent establishment, then it goes to the corporation, and that's the wrong interpretation.
Except that right after corporations primarily acting as instrumentalities of the state, they go on to say counties or municipalities.
Yes, so counties and municipalities. If the corporation is primarily acting as instrumentality of the state, or a county, or a municipality, that corporation does have immunity. But this corporation is not. This corporation is primarily acting as on behalf of JTA, which is an independent authority which doesn't have the controls that true government has. It doesn't. There's no. Their voting is irrelevant to it.
Excuse me. Do you agree that JTA is in fact a state municipal?
Yes, it's a state. Okay. It's a state. It's not state. JTA is not a state. It is JTA is an independent establishment of the state. With what JTA is. JTA is an independent establishment of the state, just
similar to a school district.
A school district, whether a school district is a county or local or municipality, a school district has, elected. It's a constitutional local. It is a.
But you agree that JTA falls under the immunity statute.
JTA
Correct.
falls under the immunity
You're
statute.
saying JTM is not a corporation primarily acting as an instrumentality or agency of the state.
Of the state, correct.
But then it goes back to that they've defined state agencies or there's some awkward drafting here.
Yes, there is. If they wanted to say state, including independent establishments of the state, but to think state and independent establishments of the state mean exactly the same thing. Obviously it doesn't, because in the first part of the subsection, they had to be separately listed. Now we get to the second part. They could easily, in drafting, said state, including independent establishments of the state. Or they could have just said corporations primarily acting as instrumentalities or agencies of any of the above.
Has this argument ever been made?
Never
before?
been made.
So let me go back to what I know you're, apparently dying for us to resolve this question, but if it is convoluted and it hasn't been decided before, how is it a departure from the essential requirements of law that must be resolved now?
Mm-hmm. This court has
You may be
accepted
right,
a certified
but I'm not
question.
sure.
Yes, I understand, what I would say is an important question of law. It is a very important question of law
But
right
you
now.
know that important question of law isn't a departure from the essential requirements of law.
But I concede that, Your Honor. And what I would say
So
is,
you're
once this
wanting
court-
us, this is my, to reach something so that your client can have early resolution of something, you want us to do something that may change the law of certiorari.
Once this court has accepted jurisdiction for a certified question, it can take up any issue that it wants and decide any issue it wants
Even though we'd
under
say,
Tillman.
well, we're going to say this could have been brought by cert because he was we're going to now not decide whether it would have met cert. We're going to decide the second issue, which is whether he meets the requirements of the statute or not. That's what you want. That's how you'd want us to write an opinion. It's always, I realize as an advocate, that's your obligation, but what people sometimes don't realize is then we've got such a greater obligation to make sure the law is stable in this area.
Yes.
What's such a big, as long as you're saying this is so important, what does it matter if you have this defendant in or not? What was this so important about this? You've got a financially responsible defendant. Are you planning, you think you can get a judgment for him in excess of the $100,000?
Oh, certainly the damages are
But
for
can't
her.
you get her?
Well in excess.
Can't you have that by having the employer in there? If they're not subject to sovereign immunity?
That's what we have. We have JTM in there, and the ruling of the lower court was that neither JTM nor Keck had the right to sovereign
But the only
immunity.
issue that's being brought up here is whether the individual defendant is.
Correct. That's all they petitioned on, but Keck only has sovereign immunity if JTM has sovereign
Well, we're not
immunity.
deciding that issue, are we? You're not asking.
Well,
even
in
asking us
deciding
this.
that Keck has sovereign immunity, you would implicitly be deciding that JTM also has sovereign immunity.
Because his is totally derivative from their status.
Totally derivative. He is an employee of JTM.
So we really want to look at that issue. If we actually get to this, we have to look as if we're deciding, does JTM have?
Correct.
Well, let me ask you this. Wasn't the trial court's decision here on this issue of statutory interpretation inconsistent with the result reached in the Pagan case, however you want to pronounce it?
I don't think so. That
helps you get cert. That doesn't mean we'd have to agree with that. we would still take a fresh look at that, but that would help on the cert issue.
It definitely depends upon how Pagan. Here are the distinctions. You have to we'll say what the distinctions are, because
as I recall, Pagan, the majority actually said the case was no case or something.
Very little. We have no precedential value.
Yeah, so I didn't know a court could do that, but that's what they did.
Yes, they did say it has no precedential value. And then the concurring opinion says, well, you can't do that. But then the concurring opinion said, but we know we're not reaching any public policy issues here because they weren't brought up below. And
there were constitutional issues that had not been briefed or just weren't at issue.
Right, and nothing was briefed on the question of the interpretation of 768.28 subsection 2, which is the definitional section, the critical section of the whole sovereign immunity statute. It's a critical question. How many people fall under this umbrella, which keeps spreading and spreading and spreading?
Was there not, in Florida, we have had in the educational arena relationships similar to this for years and years? And are there not authorities, and I would ask both sides, for example, the Marine Institutes, Dade Marine Institute, Tallahassee Marine Institute, and they enter into contracts with folks to perform certain things. And it was my understanding, I thought there were cases in that context that described who did and who did not have immunity under Florida's statute of sovereign immunity that addressed specifically that issue, and individuals who worked for that entity that's contracting with the Marine Institute, for example, taking the kids on boats, taking the kids in different things, transporting the kids. Is it not answered in that context someplace?
The question of how to interpret 768.28 subsection 2, the definitional section, has never been addressed. There are a number of cases that have addressed the question of control, whether there really is control there or not over this corporation and these employees that are out there. And control is a necessary thing for sovereign immunity, but it's not sufficient. You also have to be one of the entities that falls within the ambit.
From what you've described, I mean, these wouldn't necessarily involve that, because the Marine Institute, a school, educational institution, is certainly subject to the controls created through the authority of the government. And then you have such as the JTA, and then you have someone contracting with them just as JTM.
And there's no case that we found that's ever argued this question of the definition of 768.28 subsection 2, which,
you're saying all those have been decided on control issues?
Correct. Yes, Your Honor.
Well, how are those different from your situation? I mean,
well, I would have to take them up individually. They do vary, because control issues, sometimes they're contracting with HRS, sometimes they're contracting with someone who's clearly a state. It's how far removed you are, and ours is so far removed, and this is such a sham.
Not so far. I mean, it's not so far.
Not so far. It's 2 steps, 2 or 3. I don't know. Give me 3 steps, and
no, really, it's only the issue now focuses on, can JTM, even though we're not deciding that, have sovereign immunity?
Correct.
And that's and as you're claiming it's a private corporation, but it's not an independent establishment of the state.
It is not.
And no one's arguing it is?
No one's arguing it is. JTA is an independent. They're saying JTA is an independent establishment of the state. Well, if it's not, what is it? It's not, executive branch of the state government. It's not judicial. It's not legislative. It's not it's not a county or municipality. It's not a school board. It gets its immunity because it's an independent establishment of the state. It has 3 appointed members by the governor, 3 by the mayor. It has a member from the Department of Transportation. It does its own budget. There's been a huge to-do in Jacksonville about all these independent authorities, kind of a hybrid thing, and there's legislation.
You are now in overtime, but I'll give you 30 seconds if you want to sum up.
No, Your Honor. Thank you very much. I hope we've done a good job of presenting what is really an important issue about the breadth of sovereign immunity and the interpretation of a statute that must be interpreted in favor of limiting that immunity because it's in derogation of the common law.
Thank you. In my very little amount of time that I have left, I want to just address a few issues. First of all, to clarify one thing, there are in fact 2 ways in which Mr. Keck enjoys the immunity from suit here. One way is, in fact, which we've talked about, his status as an employee of the JTM, which is a corporation acted as an instrumentality of the JTA. The other way...
Okay, but you do go, it does say an instrumentality of the state, and what you have to do then is go back and say the state includes independent establishments of the state.
Right, which is what the legislature did in the very first clause of Paren 2.
It could have been a little clearer.
But the other way that Mr. Keck also enjoys immunity here is 768.28 Paren 9A not only grants employees immunity, but also grants agents immunity. And this court in the Stoll versus Knoll decision has said one can be an agent of the governmental entity if they are so controlled by the governmental entity, which is in fact the case here, they therefore would be entitled or be considered an agent and fall within that statutory definition.
So then would you consider JTA a subdivision under that statute?
I consider JTA to be a state agency or subdivision under Parent 2, correct?
They're an independent, you agree, they come in as an independent establishment of the state?
No, in fact, I believe they come in as the state itself. In 34904, or I'm sorry, 34902 and 03, the Florida legislature specifically said they are an agency of the state, as opposed to some of the other independent establishments like the one in Pagan, where there was no such indication in the enabling legislation.
So Pagan doesn't really govern this?
No, I think Pagan does, if you accept the respondent's argument that they're independent establishment. I don't accept that, but if you accept their argument, it does control. But I don't agree that they're an independent establishment. I believe the JTA is in fact the state because that's what the legislature has said. The other thing that the court had some concern about was unduly burdening the district courts of appeal if the rule is expanded 9.130. I would just direct the court's attention that since 1980, since the individual immunity in paren 9A of the statute has been in place, there actually have been very few cases addressing 9A in the appellate courts, maybe a half dozen or so. So I don't.
You mean after verdict?
After verdict or before verdict, there have been a few.
Well, before verdict, they're not reviewing it because there's not a non-final order, and until. I don't think anyone's argued that it was, analogous to qualified immunity.
Well,
it hasn't been litigated.
With all due respect, a couple of the DCAs, in fact, the second DCA on at least two occasions, the Andre decision and the Smith versus Rankin decisions, reviewed interlocutory the denial of an individual's immunity under paren 9A, and those cases are cited, in fact, in our briefs. Just to wrap up, because I have just a few seconds left, to allow the first DCA's opinion here to stand here would eviscerate the immunity provided to the governmental employees in 768 28 paren 9A. In addition, the trial court's order departs from the essential requirements of law, as we talked about, so we would urge this court to answer the certified question negatively, reverse the district court.
Well, you would have us rephrase that question anyway, wouldn't we? Because it talks about discretion. It would be just, is cert available to a defendant, an individual employee of the state?
That's absolutely correct, because discretionary functions really do not come into play here, because this is not a qualified immunity defense to a Section 1983 claim. So we would urge the court to reverse the first DCA with directions to the trial court to enter summary judgment in favor of Mr.
Actually,
Keck.
I have one quick question. I'm sorry. Is the citizens' property case, are you familiar with that?
I am, yes.
Do we have to be careful to be consistent in what the scope of cert is if we're going to be discussing cert between citizens and this, or do you see again the fact that this is an individual as being very different from a state-created insurance company?
Yes, as you mentioned and as this court mentioned in Roe, there is a distinction between the entities versus the individuals claiming immunity, and the policy considerations of the two are not the same. Thank you very much.
We thank you both for your arguments. We now go to the fourth and final case on today's docket, which is MIA Consulting Group, Inc. versus Hacienda Villas, Inc.
May it please the court. Brian Stack and Sammy Eppelbaum on behalf of the petitioner, MIA Consulting Group, Inc. The issue before the court is an exceedingly narrow one. The Third District Court of Appeal determined, in the face of at least 5 decisions of this court, not to apply the venue rule, which was first articulated in the Croker case and reiterated on at least 5 occasions subsequently by the court. And the Third District's reasoning was simply stated to be that because the claim of the plaintiff in the circuit court action had not asserted, or because the claim was not for liquidated damages as opposed to unliquidated damages, the venue rule articulated in Croker and progeny simply wasn't applicable. That is the sum and substance of the basis of the court's reversal of the trial court's order denying an unsworn motion to change venue, motion to dismiss for the purpose of changing venue. The third district then went on and applied two cases which, in our respectful opinion, are inapplicable to the facts here, because there is no suggestion in the underlying complaint that the plaintiff had failed to perform the services which were the subject of the services agreement. The essence of the complaint in the trial court was that the defendant had breached a contract and had failed to pay the plaintiff money due under the contract.
Wait, how could there be money due if the very agreement was, if you help me do this, I'll agree to employ you? There wasn't any contract entered at that point.
Well, the parties had already agreed to the form of the contract. Recall that the plaintiff's obligation was to prepare and submit a contract, a grant application.
Yeah, but it wasn't, the breach of the contract it's the breach of the agreement not to employ the person.
That is correct.
Your client. It's
that
the
is
breach
correct.
So they were going to employ them in Tampa.
No.
Where? In Pinellas.
In part in Tampa, but in part in Miami, to provide two different kinds of services. The HUD grant application was designed to convert a living facility into an adult living facility regulated by the state. The HUD grant was going to be used to convert that facility, and in fact, my client prepared the grant application, submitted it, and the federal government awarded the grant and
Are you
funded the money.
suggesting that the employment agreement, the following, your compensation, was already agreed upon, it was already written, it just needed a signature, or did it already have signature? What was the nature of that?
It was contained within the grant application. It was unexecuted. It had been agreed to and negotiated and was contained within the grant application.
And was that filed as part of the complaint?
No, it wasn't.
Was it filed as part of anything in connection with the venue issue?
It was not. And that failing, which the respondent contends falls at the feet of the plaintiff.
Well, I think you may have a problem with that. You've got the burden of pleading and demonstrating somehow that venue is appropriate, do you not?
No, we do not. This court has held that the plaintiff never has a burden to establish venue by pleading or proof. That when a defendant challenges venue, it's the defendant's obligation to plead it and to prove it. And all the district courts have said when a defendant elects to challenge venue, the burden is on that particular party to file a sworn pleading with the court and to raise the factual issue that they think is dispositive of the venue determination. What the defendant in this case did out of the box was file a 2-page motion to dismiss for lack of venue. It argued that the services contract, the services to be provided by the plaintiff, were going to be in Hillsborough County. But that wasn't the gist of the lawsuit. There was no complaint about the quality of any services. The gist of the claim was that the defendant had failed to pay the money that was due under the agreement.
Well, how much money was due under the agreement?
Because they anticipatorily...
How much was due?
Well, the grant application shows that there was a sum due for what were called implementation services, $120,000.
That was for the grant itself?
No. After the grant was awarded, my client was going to provide...
You mean there was a line in there that says, I'm going to spend so much for management and consulting?
That is correct.
Okay.
Is that in your
There
complaint?
wasn't a contract.
No, it wasn't. What was in the complaint...
Where is that in the record?
It's not in the record, Your Honor, but the fault of it not being in the record lies with the defendant.
You're alleging something. Someone asked you, what was... The district court, the trial court, is only looking at what's before it. It can't look at something that's not before it. If you felt like there was a claim for money due, $120,000, which, that's not maybe you're looking for millions, but that's a good start. Why wouldn't that count one of your complaint? They owe $120,000 in liquidated damages, and they haven't paid it.
Well, it did not need to be a part of the complaint. The complaint simply needed to allege a simple statement of claim for breach of contract. We did not... There's no requirement.
It's caused all of us to understand this as a case for a breach of an agreement to enter into a contract.
Well,
that's what that's what I see this as. It's not a breach of a contract. It's the breach of an agreement, a promise. If you do this for me, gratis, I'm going to then employ you down the road.
Well, it's not really that it's being done gratis. It's being done because there was an agreement that
Well, you're not, with no expectation getting payment for that.
for the preparation of the grant
It's kind of
application.
contingent compensation.
It would be
But it's
contingent.
contingent upon the success of the grant. So if we can get you the grant, then we're going
Correct.
to get the work.
And it was successful, undeniably.
And you might have, again, we're not talking, of course, of the merits of whether you can sue them. The issue just is whether the defendant, in this case, happens to be a nonprofit defendant from Tampa, right?
Well,
there's no question about that. So we're just
There's nothing in
looking
the
at,
record on that point, but I don't dispute it. But
so the issue is, where did this cause of action accrue?
Correct.
And you're saying it accrued where payment was going to be made on a contract that hadn't yet come into existence.
No, but the contract, there was a contract between the parties. The contract between the parties required my client to prepare a grant application, submit it, and if it were to be awarded, then the parties, having already agreed to the terms of the underlying.
But this was not a written contract, was it?
Yes, it was.
And where was the contract?
Was it attached to the?
It was contained within the grant application.
Was that attached to the complaint?
I'm sorry, sir?
Was that attached to the petition?
No, nothing was attached to the complaint.
Well, but again, it comes back to that's what's thrown the curve to the court system.
I hear
is
you.
that if you have a cause of action that's predicated upon a written agreement, I think our rules of procedure require that it be attached, doesn't it?
No, it does not. What it requires is
not?
we referenced the grant application in the complaint. We quoted from the grant the applicable terms of the grant application. The grant application is about 2 inches thick.
Yeah, but you're not suing on the grant application. You're suing on what you're now telling us, a contract that was already agreed to that's attached to the grant application.
Yes, sir.
And you're saying that under Florida law, you've got a written contract and that there's no obligation for the pleader to attach a copy of the written agreement. That's what you're telling us.
Well, I don't believe that there's an obligation to attach the entirety of the agreement because we referenced it in the complaint. It wasn't being hidden from the court. It certainly wasn't hidden.
Did you reference, even in the complaint, what this agreement said that you were going to get the I didn't recall seeing
there's no reference in that.
$120,000 mentioned in the complaint.
No, what's referenced in the complaint is the acknowledgement by the defendant that they had in fact retained the plaintiff to be its implementation consultant and to be its management agent. The issue that I would like to address, which seems to be a concern by all concerned, is that whose burden was it at the outset on this venue motion to supply the court with that grant application?
Not really that. It's that if venue is going to be, you get the choice of venue as the plaintiff, but the choice of venue needs to appear on the face of the pleading until it's refuted by them. Now, you didn't, obviously, if the defendant was a Miami corporation and you didn't allege it, you wouldn't expect someone to come in and say, hey, we're not a Miami corporation. But here, the only basis for you being able to sue in Miami versus in Tampa is if the cause of action accrued in Miami.
That is correct.
And you're alleging payment was going to take place in Miami, right?
Correct.
And I'm saying, let's forget the whether these cases from the 30s, are applicable. What I'm saying, just as a common sense point of view, how do you establish that the accrual is in Miami? They're saying, no, the accrual was in Tampa. That's where the services were going to be,
No one's suing on a breach of any contract to provide services. If that were the case, then the venue may well be in Hillsborough.
You're suing on a breach of an agreement to enter into an agreement for services.
Which is entirely enforceable.
No, I'm not saying it's not. We're not here on whether it states a cause of action.
Right.
We're stating the agreement to enter into the agreement. They breached it by not entering it. They breached it in Tampa. They didn't breach it in Miami.
I respectfully disagree.
Well, but I mean, that's a third, that's why I agree that some part of the third district decision is it's not a contract for services, but it's not a contract for a creditor-debtor contract either.
Well, it's purely the defendant's only obligation under the contract was to pay money to my client. It had no other obligations.
Well, didn't they have to hire him first?
We were hired because the condition to being hired was satisfied.
But you just didn't attach the contract under which you're seeking recovery.
And we didn't need to, Justice.
Rule
Lewis, my point on, I'm sorry.
Rule 1.130 requires that when you bring an action on a contract, and it mentions some other things, that you need to either attach it or incorporate it somehow to the pleading.
And we did incorporate it. We referenced the contractual undertaking of the defendant to retain my clients expressly in the complaint.
All right, where in the written contract that was incorporated in your complaint, where in that contract does it reference a specific sum certain that was due at a specific certain specific point in time?
It's in the grant application.
Where?
Yes, sir.
Well, but is it in your complaint?
No, it is not in the complaint.
Well, that's the point. You've not incorporated in this critical term in the allegations of your complaint, and I think that's what you see that we are focused on and struggling with here.
Yeah, and I understand that. And what I want to say in response to that is, I don't think we had an obligation to attach the entire grant application. But even if we did, they didn't move on that basis. What the defendant did at the outset of the lawsuit, without having filed anything else, was to say, in an unsworn motion, venue is not appropriate in Dade County, Miami-Dade County. Venue is appropriate in Hillsborough County.
What if your complaint on its face shows that it's not Dade County venue?
That would be a different issue.
Well, I'm not so sure it is, because when you file a complaint saying they didn't enter into an agreement with us, that's not the same as saying we already have an agreement, they owe us X number of dollars, and here's the written contract.
Well, first of all, the obligations of the defendant were twofold. Once the condition to moving forward was satisfied, the award of the HUD grant. They were to deliver to us the executed contract, which had already been agreed, and then to pay us. In lieu of doing that, there was a repudiation. But I get back to the notion that when a defendant challenges venue for any reason whatsoever, whether it's because on its face the complaint doesn't show a basis for venue or otherwise, and I would submit this court's prior decision in the Inverness case says we have no burden, a plaintiff has no burden to articulate venue.
It's got to you're saying those cases say it doesn't even have to be reflected on the face of the complaint?
No, not precisely.
What if it reflects that it's not in Dade County? What if it reflects that it's truly in Hillsborough County?
That would be a different situation.
Well, okay, I mean, you say that. I mean, I see your lips moving, but I'm not sure I agree with the legal conclusion.
I hear you.
That's the problem we get into by not relying upon that contract. I mean, I'm going through looking at this as though this is an action based upon the failure to enter into another contract.
Which is an entirely enforceable contractual
I'm not saying
undertaking.
it's not enforceable. That question, though, is where's the venue on that?
Exactly. So our position is, because the nature of the defendant's performance only is to deliver the signed contract, which they had an obligation to do, a contractual obligation to do, and to pay, it would accrue in Miami-Dade County. And I get back to this notion that when a defendant says, wait a second, this is not the right venue, they have, under clear authority from this court and from the 3rd District, they had to file a motion, a sworn motion, to raise the issue that they thought was significant. And the issue that they thought was significant was, wait a second, this so-called debtor-creditor rule, which is not what the court describes it, this is what the lower court described it as, but this debtor-creditor rule is inapplicable because you're suing for unliquidated damages. That's the argument that's being made. It wasn't made below. It wasn't made in the circuit court. That argument is made for the first time before the 3rd District.
And how come and so that's in the briefs? The debtor-creditor rule is in the briefs?
That's in their brief for the first time, not in their motion to dismiss.
But the 3rd District doesn't even mention the case out of our court that supposedly established it?
None of them. And the point being, if the defendant, in its motion to dismiss, had said to the circuit court judge, wait a second, there's a venue issue here because we think the damages are unliquidated, and that the whole venue determination turns on that question. It was their burden to file that grant, to even raise the issue. Whether they were going to file that grant application or not.
They filed a motion to dismiss or transfer for venue. Said nothing more.
They said nothing more.
Was there a hearing on the motion?
Yes, there was.
Was it reported?
No, it was not.
And they made some legal arguments at the hearing.
They made a legal argument at the hearing that the circuit court denied because
And what were the arguments made at the trial court?
What they argued in their motion to dismiss, which is that the services that the petitioner was going to provide under the agreement were going to be rendered in Hillsborough County.
And that was denied by the trial court.
Correct.
Okay.
Then a notice of appeal is filed. For the first time, the argument is made, wait a second, there's this distinction between liquidated and unliquidated damages, which I would submit to the court under the Duggan decision and the Croker decision and the Safety Clean decision. There is no distinction to be made between liquidated and unliquidated. But that's the argument that they chose to proceed on before the 3rd District.
Is the grant in the record or no?
I'm sorry?
Is the grant
No,
contract?
it is not.
It is not.
It is not.
Wasn't there a stipulated statement of the facts to be presented to the appellate court?
Yes, but the stipulated statement of facts said nothing more than the following. They filed an unsworn motion to dismiss that raised the notion that the underlying services by my client were going to be performed in Hillsborough. That was not the argument that they made in front of the 3rd District.
Well, how could it be stipulated facts then?
No, that was a stipulation on, because the stipulated statement of facts was there was an unsworn motion, there was a hearing that wasn't transcribed or reported, and we cited the Raymond case out of the 3rd District, which was a payment venue rule, and they cited the contrary case. There's nothing else in the record. And if they had raised
Counsel,
that issue...
I just want to let you know, you're now down to 3 minutes, so you're under your rebuttal time. You may continue.
Yeah, I would like to reserve...
I just want to, because I'm hearing that you said that $120,000 was to be paid as liquidated damages, and that statement not only isn't attached to the complaint, but it's not in the record. Is that correct?
It is not, because what went up on appeal...
I just want to know that. How can you even be arguing it to us?
I was asked a question, so I'm responding.
Well, you put it in your brief without any record support. How?
Because the reason why I raised the issue is not to inject factual issues outside the record, but to show that this issue of liquidated versus unliquidated, which was raised on appeal by the defendant, was raised in an improper way because they hadn't preserved the issue in the circuit court, which would have put the parties, which would have put the plaintiff on notice that this was the argument that they were going to make. So they then take the issue up to the 3rd District. They argue for the first time this notion of liquidated and unliquidated damages. We had no ability then at that point in an interlocutory appeal to say, by the way, Your Honors, we want to submit the grant application.
Isn't that why you put it in the complaint in the first place?
I'm sorry?
Isn't that why it should have been in the petition in the first place?
Well, in retrospect, I wish I had put it in the complaint, but that was not required in order to state a cause of action. The elements of the contract were stated. We referenced the grant application. It's not like the defendant didn't know there was a grant application. They received $5.8 million. It was manna from heaven, and they knew how they got it.
But the trial judge didn't know that, did he?
Yes, the trial judge knew it because that was in the complaint. The trial judge knew that there was a grant application. She did not know the nature or the quality of the damages that were being sought. Clearly, because that was not an issue that was raised by the defendant. It did not get raised until the appeal was prosecuted to the 3rd District when they raised for the 3rd time the distinction between unliquidated and liquidated damages, and we argued in opposition.
You keep saying that over and over again, but the stipulated statement basically says that he relied on Raymond. Raymond was a debtor-creditor rule case.
We relied on it.
Exactly.
They did not rely on...
But you said it was raised for the first time at the 3rd District Court of Appeals.
The distinction...
You raised it.
No, what I'm saying for the first time was the distinction between liquidated and unliquidated damages.
Right, but debtor-creditor rule deals with liquidated damages.
That was not the subject of the case in Raymond. Raymond did not make a distinction. In fact, the argument that we have made fundamentally is this court's decisions do not allow a distinction between liquidated and unliquidated damages. It was not something that had been raised below. If they had said out of the box, the Supreme Court's decisions on venue are inapplicable because they don't address unliquidated damages, they would have raised that issue. I would have been on notice then that I needed to do something in the circuit court.
Did you argue lack of preservation to the 3rd DCA?
Yes, we did.
And did they address that?
No, they did not. They did not. And after we asked the 3rd DCA to remand the case to the circuit court on the finding of whether the damages were liquidated.
And is that one of your points on appeal here?
No, my point on appeal here is that it is not. I believe that if the court were to determine that liquidated versus unliquidated is the dispositive issue, I don't think it is in light of the court's opinions, particularly Duggan, an unliquidated damage case involving an implied contract under general assumption. There's no way that, respectfully, I think that distinction in the law can be abided by in light of the court's decisions. But what I am saying is, in light of what the Third District did, the narrowness of its holding, it's in conflict with this court's opinions. And then the Third District took it a step further by saying, well, we're going to default to the general services rule, which says when you sue for breach of services, for breach of a services contract, you have to sue in the venue or the county where the services are to be
Counsel,
provided.
you've now exhausted all your time and you used an extra minute. I will nonetheless give you a minute for rebuttal.
I appreciate that. I was attempting to answer questions. I know
understand.
I ran long.
That's why I'm giving you a minute, an extra minute, or 2
Thank you very
minutes,
much.
2.5, really.
May it please the court, good morning. David Weisbrod from Tampa on behalf of Hacienda Villas. First of all, this court has said definitively in the Goedmaker case, Goedmaker, that the plaintiff does have a burden to allege a sufficient basis for venue in its complaint.
Well, it does do that. The complaint says that all payments to MIA would be made at MIA's principal office in Miami-Dade County.
Pursuant to a contract that they say was not delivered.
Well, but if the issue is that there was a anticipatory breach of a contract, the contract was to be performed, and the last part of the contract would have been payment. The fact that someone doesn't get away from because they actually breach it before the contract starts, that's an anticipatory breach of a contract. And you don't raise in your, you say this in your brief, but you didn't raise that that this complaint fails to state a cause of action. So all these issues we're raising about contracts being attached, you don't say that it is a deficient complaint.
Well, we were trying to figure out what exactly the cause of action was. I mean, was it for not being hired to be the implementation and operation consultant for MIA, for the villas? Was it for some other work to be done? We have no idea from this complaint.
Well, but that's the issue really is, the first issue, going back to what he said, is it correct that you didn't raise in the trial court below, in the trial court, that it should be transferred to Hillsborough because there was no liquidated sum alleged to be due?
It was absolutely raised. If you look, there was no court reporter in Miami. We prepared a stipulated statement of proceedings.
Well, your motion to dismiss for improper venue doesn't raise it, does it?
No, it just raised the issue of Hacienda being a not-for-profit Hillsborough corporation, that the services would have been performed in Hillsborough. It cites 47.051. And
okay, but you don't say, and additionally, it's not a liquidated, it's not there. So where is it in the record that we can look to?
In the stipulated statement of proceedings, in paragraph 3, the parties agreed to the third DCA that at the trial court level, each counsel presented legal argument with the plaintiff, MIA, relying upon Raymond versus Langdon Asset Management, Inc. with a citation. The defendant relied upon Morales Sand and Soil, LLC versus Kendall Properties and Investments with a citation. Morales Sand and Soil is the creditor-debtor rule. It cites to Croker versus Powell. That's right. Hacienda's case that it relied on in the circuit court cites this court's opinion in Croker versus Powell, and then goes on to distinguish it and why in cases where the sum due does not appear to be certain, that the Croker rule doesn't apply, and it very clearly says throughout its opinions that the rule is only applicable when you have liquidated damages. And then at the very end of Morales Sand and Soil, the court says this is not a case like the sale of goods where the vendor ships a known quantity to a purchaser who then fails to pay for them. In that case, the breach is the failure to pay a known sum, and the Croker v. Powell rule applies.
What does it matter for where the venue is if it's the cause of action accruing? If I agree to pay you, an attorney, at your office. I agreed to pay that amount, and I don't pay an amount, but not a specific amount, because we still are, and you don't pay anything to me. Why does it matter for the purposes, these rules that we might have, a debtor, creditor, it's a breach of a contract to pay money. Doesn't that cause of action accrue where the last act was to take place, which is where the payment was to take place?
I think it relates back to the whole purpose of the venue statute. The purpose is to have the least amount of inconvenience to the party that's being hailed in the court, which is why you can hail that party in the court where it has its place of business if it's a corporation, or residence if it's a person, where the property in litigation is located, because it makes sense. If I buy property somewhere, I should have to answer to questions about it, or where the cause of action accrued. And if you have a situation where I have performed services, I am due a sum of money without doubt as to what it is, which is what all those cases...
But accrual doesn't depend on whether it's a sum certain or not. Crocker was, as was pointed out, it was legal services. The debtor was a defendant in a lawsuit and asked and hired somebody from Jacksonville, came to him, performed services down in Palm Beach County, and there wasn't an amount specified. They got to sue, he got to sue in Jacksonville, correct?
Oh, he got to sue in Jacksonville, not on the services in Palm Beach County, as I read Croker. He got to sue in Jacksonville by rescinding the contract that had originally been entered into. The disagreement between those parties occurred on additional actions that the attorney took on, another case.
Okay,
so
are you saying Crocker doesn't even have a creditor-debtor liquidated damages rule?
No, I'm saying it does.
Well, how could it if there's not a sum of money that was due?
Because he had a sum certain on that contract. He had a contract for $2,500 plus another $2,500 due in a year plus $100,000 dependent upon a successful outcome of the appeal.
I guess I'm having trouble understanding. I'm going to take away Crocker. I'm not going to look at Crocker, okay? I'm having trouble understanding. Well, we do that with old cases, right? It has the statute of limitations.
You can.
It doesn't make sense to me that a cause of action accruing for money due depends on whether the money due is at some certain. I may be with you on that in this case. I think the third district got it right. So it's not all a hostile question here. But
you'll take that, right?
But on the actual issue, we're just here as we want the law not to look idiotic on venue, and I don't see how the fact of there being a sum certain or not affects a cause of action accruing.
Well, there's close to 50 years of consistent District Court of Appeal application of this exception. There are other exceptions, for instance, to the rule
No, not an exception.
Case.
You're saying it's exception. I'm saying that it's a part of a sum of money due, that when a contract's breached by non-payment and payment is to be made in a specific place, that's the last action. I mean, for the statute of limitations purposes, that it's the non-payment of the breach of the contract that starts things going, right? The cause of action accrues.
But your focus is on cases where, let's say, the services or the goods have been rendered and there's an amount due, and we know what that amount due is. That's one, but you're saying,
on those cases.
What about this case where there's no services rendered?
Your case?
Yeah.
Well, I like it. Your case is good for you, but not because of the debtor-creditor rule. That's all I'm
doesn't it turn on the fact that there was a contract in all these other cases and not a contract in this case?
That's certainly a distinguishing factor, and also...
And you use these rules, place of payment rules where there wouldn't necessarily... I mean, the accrual, I don't think it really matters, really, whether it accrues or not. I think it really turns on whether or not there was a contract for amount due. And the cases go all over the place. They talk about the court being able to calculate minstrelly or whether there's a simple arithmetic calculation. But if it really turns on whether there was a contract, and if there was no contract, you have to go by the statute, the 47.051 actions against a corporation. That determines where the venue is.
I agree, and we think that to the extent that there was, the accrual would have been when Hacienda didn't then bring MIA in to do this work in Hillsborough County.
Well, now, let's go back to that, because your opposition has said that very clearly on the face of this complaint that it shows that what they were actually suing on was the terms of the contract that was attached to the grant, although not attached, but the terms, not that you didn't enter into something, but that's what they were suing on, this contract that's already in existence. You just haven't signed it.
I don't read paragraph 13 of the complaint as being that definite.
Okay, well, tell me why not.
How I read it is, well, first of all, we don't know what was in the grant because it's not attached.
I understand, but he's saying from the face of the complaint, you can tell that they are suing on whatever it was that was attached there.
So that would then be Hacienda's repudiation of this contract in Hillsborough.
Well, I'm just asking on the complaints what I'm looking to.
Then that would be, the repudiation would be in Hillsborough County, which would then be where the cause of action accrued for not following through. I can't actually say, because I don't know that there's some signed contract that they were then supposed to put in the mail and deliver. That's not what's alleged. I mean, certainly.
Well, that's what he's arguing this morning, is that there was already, the contract itself was already on the grant, and that's the essence of this action.
I don't know how you can say that when in paragraph 13 they say HVI has failed and refused to retain MIA as the consultant and manager of the Hacienda Villas facility.
Well, they say it in paragraph 10. They confirmed in writing that MIA had been retained by it to implement the assisted living, and then Exhibit 9, it said the application of HUD states that they've contracted with MIA Consulting Group to implement the assisted living program and manage the supportive services. I mean, that's alleged in the complaint.
Well, but then why is it, and then why do they say failed and refused to retain MIA? I mean, that's sort of my point.
Well, I think beyond failed and refused, they say in 13 that MIA, that failed to deliver to MIA in Miami-Dade County a signed contract under which MIA is authorized to do whatever work they're authorized to do. So, I mean, as I read it, it seems that this contract, this complaint is saying that they did, in fact, fail to enter into a contract.
And if Hacienda did that in Hillsborough County, then...
Well, but isn't that what we're going back to, which is this? What is a cause of action accruing for statute of limitations in a contract case? Is it different than what a cause of action accruing for venue purposes? The last act is accrual, correct, of a cause of action?
I think so, yes.
All right. You can't have, unless you have harm, you don't have. So what is the last act in this case that was the breach? That would have started the statute running, where you couldn't raise where you could raise or not raise the statute of limitations defense.
It would have to be Hacienda Villa's repudiation.
What they're saying is you were supposed to deliver a contract to them in Miami-Dade. Now that's different than what we're now talking about, this creditor-debtor rule. That's what they're saying, that you didn't do that. You were supposed to deliver a contract and you failed to do that.
That would be saying every contract case then has venue where the contract is ultimately mailed to. That's never been the law as far as I know anywhere. What the action of Hacienda Villa is, if there was in fact a signed contract that they supposedly didn't deliver, we would see it. It would be outlined. We would know about. I mean, it's hard to.
This is like a contract to send a contract. I mean, it's just a kind of.
That's what not delivering in Dade County means to me. I can't put any other understanding on it.
But it's really the nature of the cause of action is what's sort of getting us, what's beating us down here. And I'm starting to think that, I know we took this because we said there's conflict, but did you make an argument we really that there's not really conflict?
Yes, I did. I think that's throughout the brief, and I did do a short brief on jurisdiction initially, and that point is simply that all the courts of appeal have agreed in cases of this nature, goes to the liquidated versus unliquidated issue, that, you know, if there's not a sum certain.
But I wouldn't go off on this one. It's not all the courts have agreed, because Crocker is not a liquidated amount. I think you lose on that particular
Croker is strange, Your Honor, because when you look at Mendez v. Hunt, which we cited in our brief, it has a nice review of Croker, and what it says is Croker was allowed to sue on a rescission of the express contract, chose to sue on a rescission of an express contract. We don't have rescission of an express contract here, from what I can tell from reading the complaint. So I don't think Croker has ready availability to these facts here.
I guess what I was thinking is then Croker really didn't enunciate a debtor-creditor rule based on liquidated damages.
I think it did. When you look at the underlying, Croker outlines several letters back and forth between Mr. Powell, who was the attorney in the case, and Mr. Robinson, who was the agent for Ms. Croker. And it outlines in significant detail exactly what the agreement was to retain Mr. Powell and for the services he was to perform. The disagreement then that developed was for additional work that was to be done. And because of that point, Mr. Powell said, oh, now I don't trust you to pay me on my original contract, so I'm going to rescind those and sue on that and sue in general assumption.
How does he get to sue in Jacksonville, though?
Because the contract says exactly how much money he was supposed to be paid for his work that he did in the 2 cases.
Why does that make a difference on the accrual of the cause of action?
Well, to go back to the point I made before, my supposition is it relates to the general notion about where defendants are to be hailed into court. And I think it's consistent overall with that doctrine that it's where they live, it's where they have property, et cetera.
Et cetera being where the cause of action accrues.
Right. And if it's a simple, straightforward, I delivered you 10 bowling pins and you owed me $100 and
when has
you didn't pay me.
venue ever depended on whether something's simple or not to prove?
Throughout all
That's
these
it. Now
cases.
you may be talking about an inconvenient forum for the purposes of transferring. I certainly appreciate that will occur if there's 2 equal forums. You look at the one that's, forum nonconvenience. That goes to that, but not on whether venue's proper in the first place.
When you look at all those District Court of Appeal cases and interpreting the venue cases, they are all down the line. There are very few exceptions. Employment contracts are exception. Indemnity contracts are exception.
I've never had a situation where I reread the briefs last night where you're saying they all say one thing and you're saying they all say something else other than the third district.
That's the adversarial system, I suppose.
Can't be very clear, can it?
Well, I don't think we've purposely tried to make it unclear. I think if you look at the basic allegation of this case, if MIA is suing Hacienda in Miami County, for what? They didn't render any services. They didn't do any of this work. There is no $120,000 contract anywhere to be seen in the record. It first appears in a motion for rehearing before the 3rd DCA. There's no record basis for it other than that. I think this case, clearly there's no nexus between Hacienda and Miami-Dade. Hillsboro's the correct place. 3rd DCA got it right, in short. Thank you.
I refer the court's attention to its own opinion in the Inverness Coca-Cola case, 78 Southern 2nd 100, admittedly 1955. It's venerable but never been changed, and it says, quote, "It is of the very nature of venue that the plaintiff selects it initially, but need not plead or prove that his selection has been proper, and the burden of pleading and proving that the venue is improper, is, if such is the fact, is upon the defendant." And the problem created here is that the defendant elected out of the box to file an unsworn motion, not making the arguments that it's made on appeal to the 3rd District or to the court today. The argument that ultimately counsel defaults to is there really was never a contract. That argument was not made below either, and there is a contract based upon the very authorities that counsel has cited in his answer brief, Just one as an example, the Bluvac case, 331 Southern 2nd, 359, cited at the answer brief. The rule is that it is possible for parties to make an enforceable contract binding them to prepare and execute a subsequent agreement is well recognized, provided that the agreement is definite and certain upon all the subjects to be embraced. And I think this addresses possibly your concern, Justice Perry, that, well, there was a second contract, and admittedly there was, because the parties agreed that if the condition were satisfied, the funding of the HUD grant, then the parties would enter into a defined agreement. That did not, I submit respectfully, have to be attached to the complaint. But if it did, they had an obligation to ask that it be attached, and they didn't do that when they sought to change venue. So what happens is there's a rope-a-dope where the first time on appeal, the various arguments begin to unfold. That's not liquidated. It's liquidated. And I agree with you. A cause of action cannot accrue or not accrue based upon the quality of the damages. Then the other argument is, well, you didn't really have a contract. They argue that on appeal to the 3rd District. But they back off on it ultimately because their own authorities show that what we sued on is recognized in the law. It's a subject of proof. I don't need to plead the proof in my complaint, and I don't need to necessarily attach an entire contract, although I think we've also cited authority that says if we've disclosed it, if we've referenced it, they know about it. It's not exactly a complete statement to say that we don't really know what's in our own grant application. The defendant knows what's in that grant application.
Well, it seems what you allege is a failure to sign another contract, not a failure to pay money.
But the contract provides for the payment of money, and if they default, if they repudiate, as they did, their obligation, which they clearly did here, what are the consequences of that? The damages that flow, and the contract provides for the payment of money. And all of that performance is to take place in Miami-Dade County. None of the defendant's performance was to take place in Hillsborough. And I think
Other
that's
than the execution of the agreement.
Pardon me?
Other than the execution of the agreement.
Well, the underlying agreement could be executed anywhere, and that's not an essential. The place of execution is not essential. What's essential?
That's not the question whether it's essential. The question is, where was that to be performed? That's where the breach occurred. That's where the cause of action occurred, according to your pleading.
Where it's to be delivered. It's to be delivered in Miami-Dade County. They had an obligation to deliver it to us and pay us in Miami. And that, I think, gets back to this notion under 47011. Where does the cause of action accrue? Does it really accrue in Tampa or Miami?
Counsel, we thank you.
And I appreciate the extra time.
We thank both sides for your argument. That concludes today's docket, and the court will now stand adjourned.
All right.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.